Okay.
The objections have stated that it's already concluded. Therefore, now we are conducting the election of the 94 general body on 20th. It's cannot be done because the other is conducted.
When the order was passed?
Yes, sir.
When the order was passed?
Order was passed on
31, 24.
Yes.
When this RPU is filed, when your application is filed now?
I moved the queue execution court and informed the court that entire thing is satisfied. The court, because of the order of this court, the court said, I cannot take that order. You will commissioners continue. He started the election and not yet.
No, when the trial court order passed the order? Date?
That's on 24. On my legacy, the question of you, limitation, because there's an apparent mistake on the part of, there's a mistake on the part. That's not can view.
No. But that mistake you are bringing it to the notice at the 11th hour.
No.
Now 20th is fixed for date for?
Yes, you asked me
date for?
Date for the election.
Election. So all these days you kept quiet. You could have immediately brought it to the notice of the court.
No,
Huh? Sir, 1.5 years you kept quiet.
No, I moved the court saying that it's infectious.
Yelli sir. Yelli, you moved which court?
Civil court I moved.
See, when this court has committed a mistake according to you, what the civil court can do? Civil court can correct my mistake? 1.5 years you kept quiet. And you say this, I have approached the civil court, which cannot correct the mistake.
The order is apparently no limitation.
There may not be a limitation, but you cannot explain 1.5 years silence. And approaching this court at the 11th hour on 20th, the election is fixed, do something. No. Yes, serve the notice on the other side. Issue notice. Issue notice. Yenilla, urgency yenilla. Next. Madi ban. Immediately after service of notice. List. Counsel for the petitioner seeks time to serve the notice on the learned counsel representing the respondent. He is permitted to do so. Yes, next. Date kodala. First serve ag barbek amele. ಏನಿದು ಏನ ಮೆರಿಟ್ಸ್ ರೆಡಿ ತಗೊಳ್ತೀನಿ ಒಂದು ನಿಮಿಷ ಇಲ್ಲಿ ಪಾಸ್ ಓವರ್ why you want time? Hearing of IA, sir. Simple IA ಇದೆ. Why you want time? ಏನ್ ಬೇಕು? Seeking continuation of delay, you want depositions? What are the applications that are pending? ಅದಕ್ಕೆ depositions ಬೇಕಾ? ಹೇಳಿ, you justify your submission, sir. Which is the other application? ಅದಕ್ಕೆ deposition ಬೇಕಾ? See, there must be some basis for making submission, sir. Once you make a submission before the court, you should be fully justified. What justification you can have? You are not asked to address the arguments on merits. This is listed for hearing of interlocutory application. And still you are not ready. Counsel for the appellant prays for time to address the arguments even on applications. Just after 4 weeks. Next.
Serial number 9, pages M.
Issue notice to respondent number 2. Yes.
Hearing matters. Serial number 10, Nagashi GS, personal mark.
Yes. Read with 13.2. Sole accused. How many witnesses are examined? Exhibits. How many exhibits?
Exhibit
35. Who is PW1? Complaint is exhibit. Who is PW2? Three. What is stated? No, the accused is working as this PW2 is three. PW3. PW2 यार मत. Furnished service details. Yes. PW4. Yes. PW5. What is it?
But you said that there was telephone calls.
PW6.
PW6 is IT woman, income tax officer, who is superior to
PW7.
he is the commissioner, sanction authority.
Sanction order.
Sanction order is
P23. Then PW8. His report is exhibit P25. PW9. Hmm? PW10. What he speaks? He is a puncher. PW11. What he has done? What is the role played by him? What investigation he has undertaken? PW12. His report. P33. All the witnesses have supported. What are your defense? What are the grounds on which you are challenging? Hmm. Hmm. Return to whom?
Return to the department, income tax department.
Yes, then
Then, my lord, after on 20th of January 2011, my lord, he approaches the income tax officer, his PwC, and files an application, exhibit E1, my lord, for change of address.
yes,
But thereafter, this application, my lord, is forwarded
date of application.
20th of January 2011.
Hmm.
On 20th of January 2011, on the same day, my lord, return of income tax is acknowledged. Everything is processed, my lord, and change of address is issued.
On the same day.
Same day.
And what was issued?
Exhibit E2.
Then
But thereafter, during the course of the same, my lord, we have received three statement, my lord, along with the RTA application, where it shows that on the same day can be processed and
no,
uploaded.
what is the contention of the prosecution?
The prosecution,
First, I have to understand the case of the prosecution.
but the prosecution case is on the first.
Hmm.
I demanded 1,000 rupees.
20th, same day. Hmm.
I demanded 1,000 rupees for change of address.
Yes.
Thereafter,
Hmm.
on 21st January 2011,
Hmm.
they got filed a complaint. Exhibit T3.
Hmm. Hmm.
Same day, my lord, at 2:15,
Hmm.
FIR is registered.
Yes.
But FIR sent to the magistrate same day. Thereafter, my lord, investment merger at the fourth year, the office of CBI.
Hmm.
Exhibit T4.
Then
Thereafter, my lord, the trap at 5:30.
trap merger on the same day.
Same day, my lord. Exhibit T5.
Hmm.
Which was concluded at 9 p.m.
Yes.
The recovery merger, my lord, is 9 PW1, PW3, PW10, PW4.
Hmm.
There are four other witnesses from crime. And the recovery merger was not being examined.
Now the material witnesses are PW1, 3, 6. Other than that,
10.
10. Hmm. Hmm.
Under the notice, my lord, the complaint.
What is your defense?
But my defense is, my lord, that PW6, Narayan, my lord, who is my superior officer, he was in charge of the whole section.
Hmm.
Now, there was a strike, my lord, in the premises earlier,
Hmm.
and saying that private parties
Hmm.
were being operating as computer operators in this digital system, and therefore not to entertain this private party. That is the contention.
Private system officers,
Yes,
system operators.
this system outsourcing.
No, who are on strike? All the employees.
All the employees, that is 2% and others.
Yes, then
But therefore, so that in fact this person will not consider the complainant visits the premises on 20th and sits in the reception center for us in the enclosure for 1 hour 15 minutes before the action starts. Then because complainant is not in the seat. Complainant is not in the seat. Waits for her for 1 hour 15 minutes and thereafter for that traffic.
no. PW6 being the ITO was in charge of the work. On the date, on the relevant date, there was a strike in your office.
Not on the relevant date. Earlier date. Earlier, the date is not forthcoming evidence.
No, there was a strike.
Now, this person a lot out of animosity towards the fish has given the complainant to insert this 1,000 rupees to the buyer of the table. We know what is called.
Have you given your explanation at the earliest to the investigating officer?
But if the investigation officer will not
Whether recovery measure refers to your explanation? No, no explanation at the earliest. Then, according to you, the request for change of address was the work pending, and that was processed on the very same day. So there was no official work was pending. Yes.
entire intimation was uploaded in the system on 20th.
Hmm.
You have been noted. But so far as the demand is concerned, this product is complete.
Hmm. Yes. Yes.
To make your notice that IT refund check bearing number so and you return that and then a shifted notice again. So you request you to do the helping me get the IT refund check to my new address mentioned below. Mentioned on 20th Malad, he gives this application.
Hmm.
This application is processed.
Yes.
My lord, please notice at the foot of the page, my lord, on 20th, 120, same day, my lord, it has been processed.
That is on 20th January 2010 or 11?
11, my lord.
10 ಅಂತ ಇದಿಲ್ಲ.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಲ್ಲ 10 ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ.
The date mentioned at the end of exhibit P1 is 20th January 2010. That is 2011, is it?
Yes.
My lord, thereafter, this was processed and refund of 21,000 so and so, that is with interest, my lord, 360, I think. It is mentioned there.
Exhibit?
Calcutta, foot of the page, my lord.
Yes.
Same day it is there. And this has been uploaded in the system, my lord.
21,360.
Yes, my lord. My lord, please notice in the system, my lord, 313 statement, along with that we have attached. On the same day it has been uploaded. Last page in the paper book.
Exhibit P2, what is this? You refer to exhibit P2, what is this?
My lord, exhibit P2 is the return of income filed by the assessee, my lord,
Earlier.
earlier. Now, please notice the 313 statement. My lord, the first item, my lord, Praveen Kumar, is 21,360. That pertains to the original check, my lord. Now the second check is dated 20th of January 2011. In that box, my lord.
1 minute.
My lord, electronics ECS successful is first line, my lord.
Yes.
Thereafter, on 20th, my lord, all the formalities regarding change of address has been completed.
Whether such a defense was taken during cross-examination?
Yes, ma'am, I'll point out. My lord, I'll just draw your lordship's attention to the complaint, my lord, P3, exhibit P3.
So according to you, the online transmission of 21,360 was complete on 20th.
Yes, my lord.
Complaint was came to be filed on the next day,
Next day.
and the trap was on the
Next day.
21st.
Therefore, there was no official favor to be.
Whether such a defense was taken at the earliest?
Yes, my lord. In cross-examination, we have stated so. My lord, please notice, my lord, PW6 evidence, my lord. That is my superior officer, income tax officer. PW6, my lord. Para 2, my lord. I know accused Rajeshwari was working as income tax inspector in my ward. She was under my control. I have seen her writing. Sorry, my lord.
You are reading the cross-examination?
No, my lord. Examination chief. Only one para, my lord. I'll
Yes,
read.
yes.
Para 2, my lord. I know accused Rajeshwari. She was working as income tax inspector. She was under my control. I have seen her writing and putting signature, and she was using it to process the returns. She was giving his effect to the orders, and she was using to undertake the rectification. She was using to prepare dossier report. She was using to audit objections and other work that was using to be entrusted. I know PW1 Pawan Kumar. Near about 1 year back, one day Pawan Kumar met myself asking regarding non-receipt of refund check. I was told PW1 that she was to meet accused Rajeshwari, who would provide the details. The change of address was using to be attended by the data entry operator. I further say that sometime I was using to instruct the accused to attend to such work. Now kindly go to the cross-examination.
He never says that it was already processed on the previous day.
No, my lord. What he says is he has entered this entire work, my lord, is under a key, lock and key. He has to open the computer and
Who
then
accused?
No. This person, my lord, that is superior officer.
PW6.
PW6. Only he can do it.
Where is stated?
My lord, at para 5, my lord, cross-examination. I have studied up to PUC. Since 36 years, I am working as income tax department. It is true to say that in my department, the services of private persons are using to be availed. It is true to say that such private persons were using to work on the system for entering the data. It is true to say that such private persons are called for outsourcing persons. It is true to say that the staff of my department were not happy on account of availing the services of outsourcing persons. Therefore, they went on strike.
No, when the application was filed on 20th January and on the same day it is processed, why you are making it that there was a strike? Even according to you, even the outsourcing person has done his job on the very same day. What is the relevance of referring to
Relevance
that?
of strike is this, my lord. The entire amount was been inserted inside the desk. That is the drawer of the desk.
No. In processing, I am saying, according to you, the online statement disclosed the refund of the amount online refunding.
The entire thing is online, my lord. True, my lord.
So, according to you, the outsourced person was dealing with that.
Yes, my lord.
Even he has done his job.
Yes,
according to you.
Yes, ma'am.
Then why that is being?
My lord, why
you are making much of this strike?
The strike is only for the reason that it was inserted. Why was it inserted? Out of enmity it was done is what we are saying.
So the outsourced employee is also involved in that according to
Yes, my lord.
Yes, proceed.
My lord, it is true to say that till the day of service of outsourcing persons are taking, I can say code of my user ID, which is so and so. It is true to say that I have kept the above number secret. Whenever I was to take services of outsourcing persons, I was using to open the computer, asking the said persons to work on the system. It is true to say that I was not informing my user ID to the outsourcing persons. It is
So,
true to say that
user ID password was never shared with them.
no, my lord, it is never shared.
So unless PW6 opens it,
Opens it, not it is not.
outsourcing person could not have
Could
worked
not
on
have
it.
done it. So this my lord incident, that is on 20th, he has opened it, then permitted them to, that is, feed the data, and thereafter only he has closed it. He has done it.
Data was promptly uploaded.
Uploaded, my lord. It was entered.
Yes.
It is true to say that PW1 was paid a visit to my office on 21/2011. It's true to say that PW1 told myself that he was not received his income tax refund check. It is true to say that immediately I called out sourcing person, and with the help of the said person, not change the address of PW1, and immediately income tax refund check was handed over to PW1. It is true to say that
Sir, physically it was handed over?
No, my lord, it is not. It is not.
By such a suggestion? It is a suggestion.
It is a suggestion.
It is
my lord.
against to your defense.
That is true, my lord. What happens is this income tax process, my lord, usual criminal advocates cannot understand, my lord.
But you are bound by that suggestion. You are bound by that.
That is true, my lord.
Inconsistency in your defense.
My lord, it is true to say that on 21/1/2011, I sent the accused Rajeshwari out of the office for collecting the memorandum of understanding. It is true to say that TADA were used to be paid to the employees, and if they were undertaken the tour. Now I am seeing the conveyance voucher, etc. My lord. It is true to say that the document now shown to me is in connection with reimbursement of TADA, which is marked as Exhibit D2. Now I am seeing the Exhibit P1, which was filed by PW1. It is true to say that the endorsement as per Exhibit P1B to the effect that of endorsing as refund within the date on 21/2011. This is the endorsement, my lord.
So physically the check was given or it was online transfer?
Well, it is an online transfer, with no physical transaction.
But in the statement, written statement under 313, there is reference to check number.
That is EC, my lord.
Easy is clear.
EC is successful. Please notice, my lord.
If that is ECS, whether there will be mention regarding check number?
Yes, my lord, because they wanted check, my lord. They did not want RTGS. They insist on the check payment.
Well, check means physically you have to hand over the check.
Now that is why they send it through registered profs from Mumbai SBI Bank, my lord. It is a central agency.
Then how, if the check was issued to the SSC, how can on the same day ECS successful?
My lord, please notice, my lord, uploading is different. Issuing check is different, my lord. Issuing check will take subsequent time. Uploading
ECS means what?
ECS is electronic clearance certificate, my lord. That
Sir,
is only after.
Either transfer of the amount should be electronic or through check. It cannot be both.
No, my lord, it cannot be both. True, my lord.
So ECS successful means it was
ECS
electronically transmitted.
No, my lord, what happens is electronically transmitted is agency is separate, my lord. Bank is SBI, Mumbai branch.
Yes.
Now what happens is when they send the bank, that is when they upload everything, my lord, the system directly transfers it by issuing a check. That is, it is off-sourced, my lord. Department does not handle it.
Maybe, sir, but it is, on facts, it is your contention. Check was issued. It
No.
was not online
My lord, I am
transmission.
not saying that check was issued. No, my lord, I am not saying that.
But
I am
in
only
this-
saying that I have uploaded the change of address. Now, change of address in the system is reflected.
No, this document does not refer to any change of address.
My lord, it only refers to the refund of check, my lord. This is their document, my lord.
Then this
I obtained
suggestion-
it from RTI.
Then this suggestion is also true. On the very same day, he was handed over the check.
Yes, my
refund
lord,
check.
handed over the check is not correct, my lord. What we are saying is, it was posted, my lord.
Through post,
Yeah, through post.
never handed over.
No, my lord. Once again.
See, suggestion is different,
Yes.
handed over. And in this statement, that written statement 313,
But,
you produced this.
Not much attachment to that suggestion, my lord. Why? Because it's a technical issue, my lord.
No, suggestion by the advocate
All advocate, even
binds the accused.
it is true, my lord. But what happens is this is all hyper technical, my lord.
Let us assume. The
For example,
second one, in this record, there is reference to check number, refund
Yes,
check
my lord.
number,
Yes, my lord.
and ECS successful.
Yes, my lord. Now, please notice, check is issued subsequently. That is by post only. No physical handing over is permitted, my lord. That is the reason.
No, I want to know, this ECS successful,
Ah,
it refers to what?
that is electronic
Clearance.
clearance successful, my
What is meant by that?
lord.
No amount was transmitted. Then
No
what
amount,
successful?
that is for to the instructions to the SBI to transfer it, my lord, by issuing a check. So far as the department is concerned, it is successful. They have to give a no objection certificate, my lord, income tax department to make payment. That is what has happened here. My lord, the agency which issues, my lord, the check is separate. It is generated in the SBI bank, my lord.
So according to you, on 20th itself, you have sent the check?
On the, my lord, I don't issue check. I give only permission. That is, ITO gives a permission.
Permission will be given.
PW6
PW6 will give.
saying that we have no objection to issue check.
PW6 has given the permission.
Yes, my lord.
Then what is the role of the accused?
Accused, my lord, only change of address. No role at all. That's the reason why we are saying that there's no role. He opens the locker. Digital employee, that is outsourced employee, feeds it.
Have you produced any document to show that you have, in fact, sent the check on that day to the changed address? Is there any material?
My lord,
Sent on 22nd, dispatched on 22nd.
my lord, they have produced evidence, my lord, to say that it was dispatched on such a day, my lord. I'll just show it to your lordship. My lord, my limited role is only to
You come to the cross-examination of PW1. What is your defense? in that?
yes, ma'am. PW1. Separate. My lord, please notice para 3, my lord, in examination chief,
Of
PW1.
hmm.
For the year 2009-10, I was paid excess income tax to the extent of 19,500. While I have opened the website, I came to know that the check for the above income tax return was sent to my address and it was returned. Then I went to the income tax office, range 41, found one Narayan, who told myself that I was to meet accused Rajeshwari. Therefore, I met Rajeshwari, told her that Narayan was told myself to meet her. I was filed application before the accused regarding the change of address. The accused Rajeshwari gone through my application and told myself that the application had requested the change of address that she should attend.
Yes.
Madam, para 12, madam, thereafter. I'll just take your lordship to the relevant portion.
Yes.
Para 12, the office of the accused Rajeshwari was in the 5th floor of Unity building. Myself and other trap members were waiting for the accused in the said floor. Myself and CW4 were waiting near the receptionist and other trap members on different places. It was about 5:30 p.m. Accused came near the receptionist. She went to a chair to whom I was followed. CW4 was also followed myself. CW3 was in the main door. I was taken my seat in the chair, just in front of the chair of the accused Rajeshwari. However, CW was standing by the side of the chair. I asked the accused Rajeshwari whether she had effected the change of my address, for which she told that she was effected such change in the system. She returned my application, upon which she endorsed the amount of 21,300. My lord, kindly go to 13, my lord.
And there is a demand thereafter.
Yes, ma'am. The relevant portion is marked as Exhibit P1. Accused Rajeshwari was asked myself of 1,000. Therefore, I removed 1,000 from my shoulder bag, which was handed over to the accused Rajeshwari. Accused Rajeshwari has received the above amount from her right hand. She opened the drawer, her left table, by using her left hand and kept the said amount in the said drawer. Para 13, ma'am.
1 minute. Yes.
My lord, 13, my lord. Since CW3 has directed himself to sign like running my hand twice in the head, thereafter, immediately after handing over 1,000, I ran my head thrice on my head. At the relevant time, CW3 came to the accused along with a lady officer. While CW3 came to the accused, Rajeshwari, he introduced her as he was Jacob PI, CBI Bangalore. At the relevant time, other trap members came to the accused Rajeshwari. CW3 asked Rajeshwari whether she had received the bribe amount of 1,000, which she has not replied. CW3 was told that the accused that she was under arrest. CW3 searched the drawer of the accused and found 1,000 in the drawer. Malad, next for para 15, Malad. CW3 removed the currency notes from the drawer of the accused, which was also packed and sealed seized and sealed. Now, kindly go to the cross-examination. Para 18.
Yes.
Well, it is not true to say that before the CBI officer, though I admitted my negligence regarding return of check, now I am deposing for it is true to say that the applications have been filed in the invert section. I had been to the income tax office and was filed my application in the invert section. I have collected the acknowledgement regarding filing of such application. I would like to say that I have filed the application before the CBI officer.
Hmm.
My lord, regarding the question, my lord, para 26, my lord, official favor.
Hmm.
My lord, middle of the paragraph, it is not true to say that I was put my signature to exhibit before without knowing the content. 5 pages have been typed within half an hour. It is not true to say that accused was never demanded the bribe of 1,000. Perhaps I have not paid the said amount. It is not true to say that the accused was not having an opportunity to show official favor. Therefore, there was no reason for her to demand the bribe of 1,000.
Hmm.
My lord, PW2, my lord, is the officer.
No, have you elicited anything from PW1 regarding acceptance? Your hand was tested positive for phenolphthalein. What is the explanation?
My lord, please notice, my lord, he says that is my lord, color change, my lord, PW3. At
No. PW3 Allah. First, PW1 is the complainant. He spoke in detail about the incident. What is the cross-examination to him? At the earliest point of time during cross-examination of PW1, what is the stand taken by the accused? He said, you demanded rupees 1,000, received it with your right hand, opened the table drawer, kept it in with your left hand, and closed the drawer. It was CW3 who removed the drawer and produced the tainted amount. That was the specific evidence given by PW1. What is the cross examination on that line?
my lord, on that, my lord, at para 18, my lord, 19, sorry,
Para?
19, my lord.
Hmm.
In respect of all the items, my lord, of cross-examined, I'll just read it, my lord.
Hmm.
Para 19, it is not true to say that while I had seen the income tax officer while I inquired Narayan regarding the return of check, he told myself that such return was on account of my negligence. I do not know the number of private workers who are working under Narayan. I do not know the number of officials who are working under Narayan. It is not true to say that when Narayan was told myself that the return of check was on account of negligence, I was disturbed. It is true to say that I was paid my visit to the income tax office on 21/2011. I had seen the office at about 4 p.m. and was in the office till 5 p.m. It is true to say that later on I was not paid my visit to the income tax office. Next para 20. It is not true to say that on 21/2011 itself the income tax was refunded to myself. Therefore, there was no endorsement on Exhibit P1 to that effect as per Exhibit P1B. It is not true to say that while seen from the CBI office, I had disclosed the said fact of payment before the CBI officer. He denies it, my lord, after having received. Thereafter, page 20, para 20.
Again, this suggestion in para number 20, it is not true to say that on 21 to 2011 itself, the income tax was refunded to myself. It is again inconsistent.
My lord, my lord, recording, what happens is there's a confusion that check return refund, my lord. Change of address is different, refund is different.
Yes, sir, but there is no such cross-examination, what I am saying. When you take a specific defense, that your role is only to change the address in the system with the approval of
My lord,
PW6.
even that, my lord, is not forthcoming. Prosecution case is that change of address to that effect, my lord, was done by ITO. ITO opened the locker, opened the.
PW1's version is, he approached PW6,
Yes.
requested for change of address.
Yes.
And he directed the complainant to PW, the accused. And that is why accused met you.
My lord, if it is true, my lord, then PW6 would have said, look, I opened the locker, I opened the computer, which was locked, and then I would have told her to make that entry. No, he does not say that. He opens it and tells the digital officer, my lord, to do it.
When PW1 says something, was it not necessary to cross-examine on that point?
That is true, my lord.
He is a material witness. He is the star witness who fully supported the case of the prosecution. Where is the cross-examination regarding your
But
defense?
he is not even telling the truth about the
Maybe,
application,
sir.
my lord.
See, it is only appreciation of evidence.
Application.
How to appreciate the evidence? On the basis of cross-examination. Chief examination along with cross-examination and evidence,
Lord, if
documentary
the
evidence.
documentary evidence, my lord, clearly shows that such a thing is not there. The next is, my lord, only cross-examination,
Documentary
etc.
evidence only to the effect that on 20th
My lord, I
January.
cannot be non-suited only because of.
So according to you, there was no need for cross-examining PW1 on those lines?
My lord,
According to me, it is a very important piece of evidence deposed by PW1. There should have been cross-examination.
that is no doubt
Why
true.
there is no cross-examination? Very clearly he says PW6 referred me to the accused. I went and contacted the accused. Accused said, I have already corrected your address, and thereafter demanded 1000 rupees. When I tendered it, she received it, kept it in the drawer. Such specific evidence deposed by PW1, where is the cross-examination?
My lord, thereafter, my lord, it continues, my lord. Please notice, my lord, para 21.
Sir, it runs into several pages. Unless you point out this is the cross-examination on the point, it is very difficult. What you have elicited from PW1 to disbelieve his version.
My lord, if your lordship were to permit me, my lord, please notice the documentary evidence, my lord. against his evidence in oral. It clearly shows that there is a
Documentary evidence, you mean that this document produced along with your written statement?
yes, their own application, exhibit also, their application, their endorsement. Endorsement is given there.
Endorsement is made by the accused.
No, it is not. It is by the digital operator, but they say it is the accused. It has not been
There is no
confirmed.
cross-examination. PW1 says, accused, after saying that your work is done, she endorsed it, saying that your refund is 21,300.
My lord, if that is so, my lord, then the entire work is done, my lord. How can
Sir, that should have
thereafter on 21st, my
that should
lord,
have been your cross-examination. That
my
is
lord,
why repeatedly I am saying.
thereafter, my lord, the question of coming there next day,
I fully
giving
agree.
them
I
1,000 will not arise.
I fully agree. When PW1 says it is the accused who made endorsement on my application saying that your refund is rupees 21,300. Where is the cross-examination? If there is no cross-examination, the version of PW1 in that regard is to be admitted.
My lord,
It is not in your own handwriting.
that suggestion, my lord, I put at para 21, my lord. Please notice.
Hmm.
My lord, the second part of it, it is not true to say that while I had been to the income tax office on 21/2011, one lady Asha was told myself that income tax was refunded to myself. It is not true to say that Exhibit P1B endorsement is in the handwriting of said Asha. Thereafter, my lord, I do not know whether said Asha was a private employee working in income tax department and was using the entry of data of the system. It is not true to say that though the refund was on 21/2011, I have come up with a false theory that on 21 accused has demanded the bribe. It is true to say that I am not having any difficulty to produce the income tax return and having no objection for calling such document. It is not true to say that I have not no concern with the accused. Perhaps after 21/22, I am not having any work in the income tax office. Now, suggestion, my lord, that Asha was the person who has entered it after the ITO opened it, my lord.
No, if you have not discharged any duty pertaining to change of address on the application of PW1. You mean to say the complainant never met you?
Complaint met me, my lord,
For
because
what
I was
purpose?
also inspector there.
Why?
Digital office.
According to you, it is only PW6 who is authorized. It is the PW6 who is having the password and the key. He opened the system. The outsource office, the operator Asha has done the work. She endorsed the return refund of 21,300. And what is the role of the accused?
But accused person is the only person there who knows some of the procedure, my lord.
She may know it, but what is the role played by her?
Only regarding that procedure she is informing, my lord. Otherwise, all of that is outsourced persons. They don't know the procedure. Assessing officer, my lord, that is the superior officer, has not informed them. Now, please notice, my lord, two independent witnesses were there. What they say regarding.
Sir, my question is, PW1 and the shadow witness, they fully supported the case of the prosecution.
No, that is why shadow witness.
PW1, first, before going to shadow witness, we should complete this. He says about demand and acceptance and keeping the tainted amount in the drawer. Where is your defense? Where is your cross-examination to that effect?
My lord, para 30, my lord.
30?
Middle of the paragraph. It is not true to say that PW4 and other trap members had not come there. It is not true to say that I had not handed over 1,000 to the accused. Therefore, putting the said amount in the drawer does not arise. It is not true to say that the accused was not removed 1,000 from a drawer and had not produced the same before the CBI officer.
Then how your hand was turned into pink color and it tested positive?
But one of the witnesses says that one of the hand turned pink, other did not.
At least one hand, how it could turn into pink? You have never received it, you never came in contact with the tainted amount.
My lord, please notice, my lord, there was a woman constable who came and held my hand. No, she is not examined.
Is there any cross-examination to that effect to PW1? PW1 was very much present there. That is not disputed.
Yes, ma'am.
What prevented you from cross-examining PW1?
My lord, corresponding evidence regarding shadow witness and independent witness, my lord, I'll just draw your lordship attention.
Yes.
My lord, before that, only one cross-examination of PW2, my lord. My lord, PW2, my lord. Kindly go to the cross-examination.
Yes.
Para 4, man. In the year 1980, I joined service as a LDC. It is true to say that I'm working, having working knowledge regarding the income tax rules. It is true to say that the income tax department has introduced ECS. It is true to say, that the assessee would send IT returns through an online and was not required to pay his visit to the IT office. It is true to say that the refund amount is using to credit to the account of the assessee directly from Bombay office. It is true to say that the other private persons are also on duty for attending the data entry of the returns. It is true to say that such persons would effect the entry regarding the change of address. It is true to say that the accused is not having good service record. He is having good service record.
No, here again you suggested to the witness that the refund amount is being credited to the account of the assessee directly from the Bombay office. Whereas now it is your contention, check was sent through post.
My lord, what happens is, my lord, there are two separate accounts. Please notice, my lord, department instructs the SBI office there in Mumbai, my lord, to transfer it. There is a central agency, my lord.
Sir, where is the question of issuing the check then?
Issuing a check, thereafter simultaneously it is issued and sent, my lord, by SBI office.
Sir,
There they made a request.
Cross-examination or suggestion to
Complainant
PW1,
says that you please send it through check. Therefore, it is sent through check.
your cross-examination either to PW1 or to PW2 does not suggest any such procedure. Illi suggestion, it is true to say that refund amount is using to credit the account of the assessee directly from the Bombay office. That is the suggestion. Witness, yes, yes.
Well, cross-examining, my lord. At least procedure should have been acquainted with the
Correct.
advocate, my lord.
That is the difficulty, sir. Now, when you suggest put a very specific suggestions to the witness during cross-examination, it binds the accused. You
This is
cannot
the-
disown it.
Crucial.
At least to accused in the presence of the accused, The evidence was recorded. At least accused must know the procedure. If the advocate was not knowing, it's all right. The accused was present. And the evidence will be recorded in the open court by dictating. And this is the nature of cross-examination.
Please notice, my lord, there is a confusion regarding this change of address and issue of check.
Correct,
From
sir.
the beginning.
The
My lord, please
confusion
notice.
is with the advocate for the accused, according to you. That has led to this type of cross-examination. How can you cure that defect now? Can it be cured in the appellate stage?
My lord, if your lordship want to compare the documents with that of oral evidence, then my lord, there is
Sir,
definitely
documents will
it
be
comes
there.
out.
Documents will be there. On the basis of the documents, PW1 has deposed before the court. PW2 has deposed. Shadow witness has deposed.
My lord, what the shadow witness says, I'll just draw your lordship attention.
PW3.
PW3.
Yes, PW1 aitu, 2 aitu. Now let us see PW3.
My lord, para 3, my lord, over the page.
3 ಎಲ್ಲ ಅದು ಪ್ರೀ ಟ್ರಾಫಿಕ್ ಎಲ್ಲ ಆಯ್ತು. PW ಪಾರ ನಂಬರ್ 6 ಗೆ ಬನ್ನಿ.
Cross-examination at para 6, my lord, middle of the paragraph.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
Yes.
ಚೀಫ್ ಅಲ್ವಾ ಅದು? ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್.
Chief. My lord, para 6. Middle of the page, middle of the paragraph.
Yes.
PW1 asked Rajeshwari whether she had done the work, that is, whether she had effected change of address in the system, for which accused Rajeshwari told PW1 that she was effected the change of address in the computer. She further told PW1 that he may receive his refund check within 1 week. Accused Rajeshwari asked PW1 to pay that. What was she told him? Thereafter, my lord, at para 7, my lord, second sentence, at the relevant time, one lady constable from CBI caught hold of the hands of accused, told that they are CBI officers, and the accused Rajeshwari was to cooperate. Now, PW, this is how it was. My lord, at page 46, my lord. Sorry, para 21, my lord. It is true to say that sodium carbonate solution was not prepared in the glass tumbler, and the right hand fingers of the accused were not dipped, and the color was not turned to pink. That is shadow witness admits oral
admission, sir.
one admission ಬಂದಿದೆ ಅಷ್ಟೇ.
ಏನು ಅಡ್ಮಿಷನ್ ಹೇಳಿ? ಹೆಲ್ದಿ ಹ್ಯಾಂಡ್ ಅಂದ್ರೆ ಯೂಶುವಲಿ ಎಲ್ಲಿ ಹಿಡ್ಕೊಳ್ತಾರೆ? ಹಿಡ್ಕೊಳ್ಳೋದಾದ್ರೆ ಇಲ್ಲಿ ಹಿಡ್ಕೊಳ್ತಾರೆ.
ಇಟ್ಕೊಳ್ಳಿ.
ಅಲ್ಲಿ ವಾಶ ಆಗಿಲ್ಲ.
At least she should be produced, my lord, as a witness.
Why should they, sir? Why should they? ಕೈ ಹಿಡ್ಕೊಂಡಿದ್ರು. Let us assume, let us admit, let us accept that Even then, that will not help you.
Well, like, we could have at least cross-examined, no doubt. Not
Sir, cross beda. We are accepting your suggestion. How the ಬಂದು ಹಿಡ್ಕೊಂಡ್ರು ಅಂತ. How it will help you? ಕ್ರಾಸ್ ಬರೋದು ಯಾವಾಗ ನಾವು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದಾಗ. Let us assume, let us accept your defense.
No, please notice, PW1 does not say about this witness.
That is not the material contradictions. This is all very minor things. Cross examination ಅಲ್ಲಿ ನೀವು ಕೇಳ್ತೀರಿ ಅವ್ರು ಏನೋ ಹೇಳ್ತಾರೆ. Everything material contradiction when it goes to the root of the matter. It is very well settled. All contradictions will not lead to the acquittal of the accused. It is only the material contradictions. What is the material contradiction?
Well, so far as admission itself is concerned, my lord, that glass tumbler right hand fingers of the were not dipped in the color and not turned pink, my lord, it is quite material.
There is no such cross to PW1.
My lord, he has not stated so.
He has stated. He has stated. Both the hands, hand wash turned into pink color. That is the evidence.
That suggestion, my lord, he denies it. But please notice, my lord, for him, there was no intention or occasion. I don't know why he has come and.
That you have to explain, sir. When you have nothing to do with the complainant, why the complainant should come to you? You should explain. And even in cross-examination, there is full of confusion. ಚೆಕ್ ಹೋಯ್ತಾ ಆನ್ಲೈನ್ ಹೋಯ್ತಾ ಎಲ್ಲಿ ಹೋಯ್ತು ಅವರಿಗೆ ಡೈರೆಕ್ಟ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ರ ಪೋಸ್ಟ್ನಲ್ಲಿ ಕಳಿಸಿದ್ರ ಅದನ್ನ ಯಾವಾಗ ಅವರು ಎನ್ಕ್ಯಾಶ್ ಮಾಡಿದ್ರು ನಥಿಂಗ್ ಸಿಸ್ಟಮೆಟಿಕ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ವೇ ಇಲ್ಲ ಅಲ್ಲಿ ಏನೋ ಇಲ್ಲೊಂದು ಸ್ವಲ್ಪ ಕೇಳೋದು ಅಲ್ಲೊಂದು ಸ್ವಲ್ಪ ಕೇಳೋದು ಏನೋ ಒಂದು ಸಜೆಸ್ಟ್ ಮಾಡೋದು ದ ಫಸ್ಟ್ ಕಂಟೆನ್ಷನ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ದ ಚೆಕ್ ಡೈರೆಕ್ಟ್ಲಿ ಟು PW1. Second contention, it was sent through post. Third contention, online, directly Bombay office in the transfer. Which version is to be believed? Then what is the role of the accused then? Why the complainant was directed to her by PW6? If she has no role to play.
Lord, please notice this, my lord. Even as per the version of PW6 himself, he is the person who opens the locker, closes the locker, that is the computer, my lord.
PW6.
He is the income tax officer.
Yes.
And thereafter, my lord, he says that he instructed this digital officer, that is outsourced person, to do it.
So everything was done by PW6. He opened the system by using the key and the password and permitted the computer operator. Then where is the role of the accused? Why PW6 asked PW1 to go and meet the accused? What is her role then?
Her role is only to guide the procedure, nothing else.
ಅದನ್ನ ಎಲ್ಲೂ ಬಂದಿಲ್ಲ ಅದು ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ಗೆ ಅದೇನು ಗೊತ್ತಿರಲಿಲ್ಲ accused ಗೈಡ್ ಮಾಡಿದ್ರು.
Material circumstance is what, my lord, that he comes and opens it.
When the accused has nothing, no role to play, why complainant is to be directed to her?
My lord, other independent witness, my lord.
Yes.
My lord, in fact, my lord, in so far as the check is concerned, my lord, they have produced evidence. Exhibit P 21.
Exhibit,
Exhibit P 21.
what is that?
My lord, the check issued, my lord.
No, 21 is not the check. It is only the statement.
Exhibit P 21.
21 is not the check,
My
sir.
lord, check column, that is
Statement. Either
Ah.
this is the document.
next page. My lord. ಅದೇ
Next
ಅದೇ
page ನಲ್ಲಿ ಇಲ್ಲ,
ಅಲ್ಲ ಅಲ್ಲ
receipt
ಅದೇ
ಮಾಡಿ.
ಅದೇ ಅದೇ ಅದೇ
ಹಾ.
ಪ್ಲೀಸ್ ನೋಟಿಸ್ ಮೈ ಲಾರ್ಡ್ exhibit P 21. My lord, after the department sent it to the SBI, my lord, now SBI in turn has sent it on 3rd February 2021. 22nd, please notice two dates, my lord. 22nd January 2011, the receipt, check date, my lord. And 3rd February, my lord, that is Pawan Kumar complainant withdraws it on 3rd February.
How you reconcile this exhibit P21 with your statement produced along with the written statement?
My lord,
313.
we intimate to the SBI, my lord, by transfer of funds. Now SBI in turn issues this. We have directly we cannot do it, my lord.
Correct, I understand. But in this statement produced by you as part of your defense during 313 statement, there is reference to a check number.
Yes, ma'am.
There is date of check.
That is department generates it and sends it, ma'am.
Why the department should issue check when you are holding the account with the SBI?
No,
Here
the-
intimation is sufficient, or whether you issue the check.
Check is issued, my lord. That is a RTI application, my lord. I obtained it. It is not something which was obtained given by the department themselves.
Sir, I am not doubting. I am asking you the clarifications.
Clarification is that, my lord, the check has been issued at that stage, my lord. This
Check
was
is
in
issued to the-
2011, my lord.
Check is issued to the SBI,
SBI.
not to the
No, ma'am.
not to PW1.
No.
Then why his name is mentioned?
Because it has to be issued to him. No, what your lordship is doubting is why it should be issued in the name of SBI.
See, in this statement you produced along with your statement under 313,
Yes, ma'am.
date of check is 20th January 2011.
Yes, ma'am.
Check number is different.
Yes, ma'am.
It was in the name of Pawan Kumar, that is PW1. That is for rupees 21,360.
My lord, please notice, my lord, the name is not mentioned in the check, my lord.
ಅದು ಯಾರು ಪವನ್ ಕುಮಾರ್ ಅಂದ್ರೆ ಯಾರು?
Pertaining to Pawan Kumar, my lord. It is not in the name of check. Check is not issued, my lord. I am not producing the check.
Refund details.
It is
of
only the
old-
details, my lord. If I have produced the check, that is a different issue, my lord.
No one needs to explain that. Here, your check is dated 22nd January 2011. Again in the name of Pawan Kumar.
My lord, it is issued against the name of Pawan Kumar, my lord. He is holding that PAN number, and to that effect, it is issued, my
I
lord.
don't know. Sir, what I am asking you, was it not necessary to explain these documents? Who has to explain that?
My lord, it is the case of the prosecution that that is entire amount was not passed on. That is their case.
Yes.
When they say that it is their case that it was not passed on, I have to show is that it was passed on.
Yes.
That is
To
what
show
I am
that-
saying, ma'am.
To show that you are relying on exhibit P21,
Yes, ma'am.
right? You are also relying on your statement produced along with your written statement, 313 statement. I am asking you, there is inconsistency between these two documents. What is the explanation? Who is required to give explanation? In 313 statement, you kept quiet. You denied everything and produced this. Who has to explain this?
My lord, the initial stage, my lord, they have to at least say that this amount has been transferred to them. It was not transferred.
Where is
They
the cross-
clearly admit and say that it is not transferred when they have received it.
Where is cross-examination to PW1? Was it not? PW1 was very much in the box. What prevented you from cross-examining him? He will be compelled to give answers.
My lord,
If he had
my lord, he
encashed the
continues to deny everything, my lord.
That is
Simply denial.
Yes.
We have put questions, he simply denies it.
That
But
is
the
the-
document evidence is against him.
Sir, you cannot
Totally
plead,
against him, my lord.
cannot plead in helplessness, sir. That is the art of cross-examination. You can do wonders in cross-examination.
That is no doubt true, my lord.
Yes, simply say whatever we ask, he is going to deny. Why I should cross-examine? Hmm? And when it is more so, when it is borne out by records, it would be more safe.
Yes.
But the attention of PW1 should have been drawn. When it is your contention that a check was issued to refund of the excess amount,
My lord,
what prevented you from asking you, see, you have received the check, that amount was credited to your account on such and such a date.
yes, I agree. Hmm. My lord, please notice evidence of PW1. My lord, took place on 23/4/2012, my lord. This RTI application,
Hmm.
they furnished the information after 14/8/2012. At that stage, this was not available, my lord.
Hmm.
My lord, please notice, my lord, this exhibit P21
Hmm.
is the website, e-portal, my lord. Which gives an update. On the same day, my lord, it is notified there. Now, please go back to one page also, my lord, at exhibit P20.
Hmm.
My lord, this document is again printout, my lord. Now, in this, it is in respect of refund. My lord, actually, this entire page, my lord, should reflect what we have produced, my lord. It is not reflecting that. This.
I cannot make out anything from
Ah,
either
that is it, my
PW
lord.
exhibit P20.
No, they are trying to say,
Even.
but they're trying to say, please notice at evidence of PWO 6, my lord. At para 4, my lord.
Hmm.
Para 4 In the year 2011, as per the request of CBI officer, I was produced 2 screen prints in connection with the change of address. They are marked as exhibit P20 and P21.
Is the evidence of?
PW6.
PW6, Manoj.
Ah,
Assing office.
yes.
I put my endorsement and signature, which are marked as exhibit P20A and P21A. I was put my signature on the receipt memo and marked as so. In the month of March, the CBI officer was called myself to the CBI office and drawn the merger exhibit P6. Now, very same document, Manoj, that is the screen print. When it is issued to me, clearly shows that that refund was generated, whereas their screen print, Manoj, does not reflect that. It shows that there is a, that is in respect of exhibit P20. P21 again, my lord, clearly shows that the refund has been issued. Check has gone to them. And then cash.
Check details 22/1/2011.
22/1.
2011.
22/1/2011. On 3rd February 2011, by post it has reached him. And then cash. My lord, check number clearing date, my lord. Thereafter, next line, my lord, paid. Well, therefore, what the evidence clearly reflects is that PW6, my lord, clearly says that it has been transferred. He himself says,
Much after the incident.
yes, my lord, it is much after the incident.
So,
My lord,
receipt of the check after 22nd, 23rd, clearance of the check on 3/2/2011. It is not in dispute.
my lord, I
But
am
it
not
is
on that issue.
much after the incident.
My lord, I'm not on that. I'm only trying to say, look, the screenshot which is on the website, my lord, insofar as when documents are given to me under RTI application subsequently, when they produce all this material, I applied and obtained it. It clearly shows something other than this, which is not correct, my lord. They should at least be.
Sir, you are part of the institution.
No,
You
my
are
lord,
working in the institution.
my lord, I had by then been suspended. I had no access to the
At
department.
least you know what is the procedure adopted in the,
My lord, I
in the
cannot.
department.
The screen procedure, my lord, I cannot access it. It is all locked.
You need not have to access. You cannot access.
I am
know
just
that.
only saying, my
But
lord.
at least you can explain.
No, I am just saying that this and that is the very same document which shows different versions, which is not suppression, my lord. It
Is
is.
there any cross-examination to the investigating officer?
It is not.
Was it not necessary?
My lord, the cross-examination.
Simply saying this is different, so I quit.
Cross has already taken place, my lord. That evidence was over.
PW6 has produced exhibit P20 and 21. It was marked through PW6.
My lord,
IO was examined later.
IO was
What is the
PW4,
cross-examination
my
to
lord.
IO?
IO is PW4, man.
You could have recalled that witness if you wanted. No court will deny that.
It was only after I obtained all this.
At least you could have asked the details from PW6. He is your superior officer.
My lord, only after he furnished all this, we obtained RTI application because they were
Sir,
putting.
PW6 is the competent persons to speak about all these things. You are not disowning him. He is your superior officer. It is not your contention that PW6 is having any ill will against you.
But I clearly pointed out, my lord, this change of address was the entry by a data operator, PW6.
But then what is your role, sir, in the whole
My lord, my only role is advisory, nothing else.
what advice you have to give, sir? There is
My lord,
PW6, your superior officer.
technically we are just advising them, my lord. They are all operators.
Why your advice is required for PW1, sir? PW6 is the
My lord, for
superior
example,
officer.
for only illustration, my lord, entire thing is on the website. He notices it on the website 3 months earlier or 4 months earlier. Thereafter, that is check return. Thereafter, he approaches in 1 day, my lord. Everything address change, it has happened on that day itself, which he again can notice in the.
You change of address, you have not done it. It is done by one Asha, private
Yes.
computer operator.
Yes, ma'am.
That is why I am asking you, what is your role then? Advising whom? Asha?
Not all the operators are all outsourced persons, so we have to
Outsourced,
tell
yes,
them
sir.
that's all, my lord.
PW6 has, in clear terms, said, I referred PW1 to accused. There is no denial to that. You are not denying that PW1 had came and contacted you,
No.
right? That is why I am repeatedly asking, what is your role then?
Well, my real role is very limited, my lord. That is only to advise the other people, ma'am.
Then why PW1 should come to you?
PW1 came to me because that is PW6 sent him there.
Why PW6 has sent?
So PW6 has sent only for the reason that entire data entry has to be made. Or the entire
Doing the data entry.
I am not doing it.
It is one Asha,
Yes,
private
ma'am.
operator.
Because she is not a permanent employee, my lord. That is why they entrusted that to me, ma'am.
Yes, ಏನು ಇಲ್ಲ. Very tough case. Very shabby cross-examination.
So far as that.
Very difficult to come out. Sir, problem is there is no cross-examination on very important points. And on the other hand, inconsistent defense was suggested to the witnesses. I can point out 4 versions during cross-examination. First suggestion is address change aitu, immediately the check was handed over to PW1. That was the suggestion, that was denied. The second suggestion, check was sent through post. Third suggestion, immediately online transfer from our office. Fourth suggestion is the online transfer from Bombay office. Which version is to be believed? And why there is inconsistency in taking defense?
Please notice, my lord, income tax officer, my lord, is the most person who can state all the procedures. He has not disclosed it.
Sir,
Now, why?
PW6 is the person
Yes, my
who
lord.
is competent to answer everything.
Everything, true, my lord.
You
But,
have not availed that opportunity.
my lord, he has not come out with that, my lord. If he has said that all
He
this,
should say so. You were subjected to cross-examination. You could have asked him. Can you not ask him? I can understand if the prosecution withheld PW6, definitely an adverse inference will have been drawn. But here it is not so. PW6 is a material witness and he is examined.
my lord, if your lordship were to notice exhibit P20, my lord, the screenshot, it clearly shows that it is different from what we have actually produced, my lord, as RT application answer. That is something which we are trying to say, that what he is saying is not correct.
Prevented you from cross-examining PW1, PW6.
PW6, my lord, this information was not available at that stage. We could have recalled it, my lord, as your lordship suggested, but that has not happened.
He provides for everything. It is a heaven, in fact, for the accused. Such procedures are provided there. But nothing, ಏನು ಇಲ್ಲ.
Court is denial.
ಅಷ್ಟೇ, ಆ ಡಿನಯಲ್ಲೂ ಇನ್ಕನ್ಸಿಸ್ಟೆನ್ಸಿ. ಟೋಟಲ್ ಡಿನಯಲ್ ಆಗಿದ್ರೆ ಐ ಥಿಂಕ್ ಸೇಫ್ ಆಗ್ತಿದ್ರು ಅನ್ಸುತ್ತೆ. ಅಂಡ್ ಸಜೆಸ್ಟಿಂಗ್ ಸಮಥಿಂಗ್ ಡ್ಯೂರಿಂಗ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. PW1 ಗೆ ಒಂಥರ, PW3 ಗೆ ಒಂಥರ.
But regarding this lady constable, my lord, one judgment I'll rely on.
ಅದೆಲ್ಲ ಆಯ್ತು ಸರ್, ಅದೆಲ್ಲ. She is not a material witness. I said I accept your contention. She was there. She came and caught out of your hand. What next?
Hand, my lord, your lordship is referring to wrist, my
Yes.
lord. No, she caught out of the hand.
ಅದನ್ನ hand ಅಂದ್ರೆ really, that is the palm. ಯೂಶುವಲಿ ಇನ್ ಕೋರ್ಸ್ ಯಾರೋ ಬಂದು ನಿಮ್ ಕೈ ಹಿಡ್ಕೊಂಡ್ರೆ ಎಲ್ಲಿ ಹಿಡ್ಕೊಳ್ತಾರೆ ಸರ್?
ಕೈ ಶೇಕ್ ಹ್ಯಾಂಡ್.
ಶೇಕ್ ಹ್ಯಾಂಡ್ ಅಲ್ಲ ಇದು. ಪೊಲೀಸ್ ಹೋಲ್ಡಿಂಗ್ ಯು. ಶೇಕ್ ಹ್ಯಾಂಡ್ ಅಲ್ಲ, ಫ್ರೆಂಡ್ಲಿ ಶೇಕ್ ಹ್ಯಾಂಡ್ ಅಲ್ಲ ಇದು. ನಿಮ್ಮ ಫ್ರೆಂಡ್ಸು ಕಲೀಗ್ಸು ದೇ ಮೇ ಶೇಕ್ ಹ್ಯಾಂಡ್. ಅದಲ್ಲ, ನೀವು ಶೇಕ್ ಹ್ಯಾಂಡ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿಲ್ಲ.
The hand, my lord. She says definitely hand, my lord.
ನೋ ನೋ ನೋ. ಹ್ಯಾಂಡ್ ಇಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೂ ಹ್ಯಾಂಡೇ. She cannot be a material witness. No. PW6, yes, material witness. See, the prosecution is required to prove pendency of work, demand, acceptance, recovery of the tainted amount. PW1, PW3, and the investigating officer and punch witness. All the 4 witnesses consistently deposed. Yes.
There's no motive, there's no demand.
Motive ಏನಿರುವುದಿಲ್ಲ ಸರ್. For demanding dowry, bribe. Motive is to receive ಅಷ್ಟೇ. That is the only motive. ಬೇರೆ ಏನಿರುತ್ತೆ motive? To enrich himself ಅಷ್ಟೇ. That is the only motive.
ಅಷ್ಟೇ. It is totally.
ಏನಿಲ್ಲ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಸರಿಯಾಗಿ ಇಲ್ಲ. Now you cannot improve it.
Please don't non-suit the accused person for erroneous cross-examination, my lord of the counsel.
Sir,
no doubt true, my lord, that is the principle.
Evidence.
But please look at the documents, my lord, which clearly shows.
Even if the documents are to be believed,
clearly shows
the
that
documents, what you mean to say, the document discloses the check was forwarded to PW1 and he encashed it. Admittedly, that is after the incident. How it will come to your rescue?
What was the complaint? My complaint was for regarding change of address.
Yes.
Change of address has taken place on 20th itself, my lord.
Yes, on the same day you demanded. That is the
20th,
contention of the prosecution.
my lord, 20th I have not demanded, my lord. My lord, I have given it also. What they have accepted, it has been done.
See, on the same day, 20th, change of address was effected. And on the same day, you demanded, that is the contention of the prosecution. Subsequent issuance of check is never disputed by PW1.
My lord, please notice the telephone call where the demand is alleged to have been made, madam.
That was transcribed, the conversation.
Exhibit P6.
Yes.
My lord, it is at the next page, madam. It is
The conversation was recorded in what?
my lord, in a digital voice recorder. 65B is not produced.
Have you raised any objection?
It is- But please notice, my person speaking person, there is no demand, my lord.
See, the complainant asked, how much, madam? What is the answer? I told you, no morning. Then he said, okay, don't, cannot you, reduce it, madam ಅಂತ ಅವ್ರು ಕೇಳ್ತಾರೆ. ಸ್ವಲ್ಪ, can't you reduce it? No.
But,
What does it mean?
but where is the demand is not there. If
Sir.
I had asked for 1,000 rupees,
You mean to say, suppose my court officer demands you, ಬಂದು ಸರ್ ನನಗೆ ಲಂಚ ಕೊಡಿ ಸರ್ ಅಂತ ಕೇಳ್ತಾರ? Can we expect that?
That is how the Honorable
ಇವಾಗ
Supreme
ಎಲ್ಲ
Court,
ಬಹಳ smart
Honorable
ಆಗಿದ್ದಾರೆ ಸರ್.
Supreme Court has interpreted that, my lord,
Yes,
phone conversation.
yes.
And they have said
Can
that
you
it should be explicit.
explicit demand, ನನಗೆ ಲಂಚದ ಹಣ ಬೇಕಾಗಿದೆ, ನೀನ್ ಕೊಡ್ಬೇಕು, ಇಲ್ಲದೆ ಇದ್ರೆ ನಿನ್
Like,
ಕೆಲಸ
otherwise, there
ಮಾಡ್ಕೊಡಲ್ಲ.
is no demand, my lord.
ಸರ್ ಇವೆಲ್ಲ ಬಿಡಿ, we have traveled a very long way. ಇವಾಗ ಸುಮ್ಮನೆ ಕೂತ್ಕೊಂಡ್ರು ಡಿಮಾಂಡ್ ಅಂತ ಅನ್ನುವ ಮಟ್ಟಕ್ಕೆ ಬಂದಿದ್ದೀವಿ. Without attending your work, if a person, official keeps quiet, sits on your file, nothing but demand.
Lord, shall I draw your lordship's attention to the Honorable Supreme Court judgment on that?
ಆಯ್ತು ಸರ್, ಕೊಡಿ, ನಾನು ನೋಡಿದ್ದೀನಿ, ಕೊಡಿ. ಮೊದಲೆಲ್ಲ ಪಾಪದವ್ರು ಅವ್ರು ಏನೋ ನಮ್ಮ ಕಾಲದವರೆಲ್ಲ ಮಾಡ್ತಾ ಇದ್ರಿ, ಇವಾಗೆಲ್ಲ ವೆರಿ ಸ್ಮಾರ್ಟ್ ಜನರೇಷನ್.
Lord, this is also 2011, my lord. This is not 2011.
ಅದಕ್ಕೆ ನಮ್ಮ ಕಾಲದವರು ಅಂತ ಹೇಳಿದ್ ನಾನು, ಅದಕ್ಕಿಂತ ಮೊದಲಿನ. The Supreme Court has also said, need not be stated in explicit words, even the surrounding circumstances will speak.
Lord, yes.
Men may lay, documents may lay, but circumstances will never. What is this conversation? ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡಿ ಮೇಡಮ್. ನೋ. ಅದು ಯಾವ್ದಕ್ಕೆ ಹಾಗಾದ್ರೆ ಕಡಿಮೆ ಮಾಡೋದು ಏನನ್ನ? ಇವ್ರು ನೋ ಅಂದಿದ್ದೇನನ್ನ?
But please notice the charge, my lord.
Yes.
Charge is regarding change of address, enabling him to receive income tax refund of 19,000.
Yes.
Now, if your lordship were to omit that cross-examination part regarding the check, my lord, then, my lord,
I may have to omit so many things to give a clean sheet to the accused. I may have to ignore so many things. Change of address you have done, but the contention of the prosecution on the same day,
next
at
day,
the same time, you demanded.
next day, my lord.
Next day alla.
Oh, next day.
21st ಗೆ, 21st ಗೆ.
21st.
Yes.
Next day.
Yes.
After, my lord, there was change of address.
Initial demand was on the same day, and therefore the complaint was scheduled to be filed.
My lord,
Trap was on the next day.
my lord, if the address had been changed, there was no occasion.
Correct.
So, cannot improve the cross-examination. No.
Sir, this is the difficulty. ಈಗ lengthy cross examination ಮಾಡ್ಬಿಡ್ತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ, and days together. It will not be concluded in one sitting, two sitting, 4, 5, 10 sittings. This is the problem. It will definitely go against the accused, not against the prosecution. So many details are elicited. That will also go against the accused.
Please.
ಅಷ್ಟೇ. Yes. ರಿಪ್ಲೈ ಯಾರಿಗೆ?
CBI.
CBI ಆರ್ಗ್ಯುಮೆಂಟೇ ನಾನ್ ಮಾಡಿದಾಗ ಆಯ್ತಲ್ಲ. Ask him to come. Ask him to come. Yes, ask him. Please go and ask him to come. Please be seated, sir.
Please.
The accused in special CC number 110 of 2000.
Sanction your lordship referred to exhibit, my lord. That is not forthcoming. Your lordship may have a look at the original records.
Sanction is exhibit. 23. 23. 23, it is here, sanction order.
Please.
It is there. Special case 110 of 2011 on the file of so and so. He is impugning the judgment of conviction and order of sentence dated 28 September 2012, convicting him for the offence punishable under sections 7, 13(1)(d) read with 13(2) of PC Act and sentencing him to so and so. Case of the prosecution in brief is that the accused was working as inspector in the Department of Income Tax, and he was a public servant. On 21/2011, at about 7:35 p.m., the accused, by abusing her official position, demanded and accepted illegal gratification of ₹1,000 from the informant PW1 as a reward to change his address in the departmental system for the purpose of giving income tax refund and thereby committed the offence punishable under section 7, 13(1)(d) read with 13(2) of so and so. It is the specific contention, it is the contention of the prosecution that the informant PW1 is an income tax assessor. He has submitted his income tax returns requesting to refund the excess income tax of ₹19,990. The same was accepted by the department and refund order was forward and a check was issued to him to his known address. It is the further contention of the prosecution that PW1 had changed his address and therefore he could not receive the check sent through post. On the other hand, the same was returned to the department. After coming to know about return of the check, PW1 approached PW6 and submitted an application for change of his address to enable the department to issue the check and forward it to the proper address. The application for change of address is as per Exhibit P1. Next part. It is the further contention of the prosecution that PW6 has referred the informant to the accused who was working under him as income tax inspector. It is then the informant approached the accused and requested for change of address. The accused, even though smeared with phenolphthalein powder to the complainant with a direction to go and meet the accused. Next part. It is the contention of the prosecution that on 21/1/2011, PW1, along with the shadow witness PW3, went and met the accused in his chamber, in his office. The accused informed PW1 that the change of address is already effected in the system, but asked whether he has brought what he had asked for. When informant tendered the entrusted currency notes, the accused received the same with his right hand, kept it in the table drawer with her left hand. Immediately, the informant gave signal to the investigating officer, who came to the spot, introduced himself. Both right and left hand wash of the accused was taken in the sodium carbonate solution separately, which turned into pink color. When the accused asked to produce the tainted amount, the entrusted currency notes were found in the table drawer of the accused, which was recovered by the investigating officer. Thus, it is the contention of the prosecution that the accused, being the public servant, demanded and accepted legal gratification of ₹1,000 from PW1 to show the official favor, that is to change the address of PW1 in the income tax system to allow issuance of the check to the said address. Next part. After investigation, charge sheet came to be After investigation, charge sheet came to be filed for the aforesaid offence after obtaining necessary sanction to prosecute the accused. The accused appeared before the trial court and pleaded not guilty. He claims to be tried. He and she and yes, the prosecution, in order to prove its contention, examined PWs 1 to 12, got marked exhibit P1 to 35, and identified MOs 1 to 4, 1 to 7. The accused has denied all the incriminating materials available on record in his statement under 313 of CRPC. He filed the written statement stating that she has been falsely implicated in the matter. The refund work was being done by the outsourced employee. The complainant had given the petition to such outsourced employee on 20th January 2011. On the same day, the refund amount of ₹21,360 has been refunded by entering the same online and to evidence the same, the accused has produced certified copy of the refund details which evidence that the refund was processed on 20th January 2011, but the complaint was going to be filed on 21/1/2011. Therefore, the complainant contended there was no demand on the client's right to show the official favor. Official favor. The information sought by the accused from the department and such information received and the rightful information is produced according to which check bearing number 4021491809 dated 20th January 2011 was issued to the complainant for rupees 21,360 and ECS was successful. ECS was successful. Thus, it is the contention of the accused that no official work was pending with him. It was the outsourced employee who effected change of address and the refund was processed on 20th January itself. And there was no demand or acceptance of illegal gratification. The trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is successful in proving the guilt of the accused beyond reasonable doubt, and accordingly passed the impugned judgment of conviction and order of sentence as stated. Being reviewed by the same, the accused is before this court. Also, here is the materials. Point for consideration, my answer to the above point. Yes, anything? See, it is his contention. No official work was pending with the accused.
Section 7 explanation.
The
Pendency not of any work is not a ground.
yes. See, the complainant has approached PW6, the higher officer, and he instructed the private computer operator to change the address. Accordingly, it was changed on the same day. So there was nothing to be done by the accused.
Section 7 explanation not
Yes.
his answers, not his contention that
Correct.
pendency of work.
And regarding
Otherwise-
demand, there is no evidence regarding demand because the work was already completed on 20th January itself.
So work pendency or otherwise not, I think explanation not
Correct.
answers. But the moment it is recovered, section 20 comes into operation. All this not.
And it is also his contention. It was elicited from. It was not rather elicited during cross examination.
Let's maybe
In the
suggestion.
chief examination, the witness PW3 says there was a woman police constable who held the hand of the accused, and that police constable was not examined, who was a material witness.
ಅಲ್ಲ held hands ಇಲ್ಲಿದ್ರ ಅಂತ ಕೇಳ್ಬೇಕಾಗಿತ್ತು.
ಅವರು ಶೇಕ್ ಹ್ಯಾಂಡ್ ಕೊಟ್ರು ಅಂತ.
That may be only suggestion, not proved.
Correct. ಅದನ್ನೇ ನಾನು ಹೇಳಿದೆ, ಪೊಲೀಸ್ ಹಿಡಿದ್ರೆ ಇಲ್ಲಿ ಹಿಡಿತಾರೆ, ಫ್ರೆಂಡ್ಸ್ ಹಿಡಿದ್ರೆ ಈಗ ಹಿಡಿತಾರೆ.
ಅದಕ್ಕೆ ಹೇಳಿದ್ ನಾನು ಇಲ್ಲಿ.
ಪೊಲೀಸರು ಬಂದು ಶೇಕ್ ಹ್ಯಾಂಡ್ ಮಾಡಲ್ಲ ಯಾರಿಗೂ.
These are all the stock suggestions not in any given case in section 7.
ಇಲ್ಲ, I pointed out there are fatal inconsistent suggestions. No explanation was obtained by the accused initially.
ಅದು generally literally what was the
I
explanation?
didn't find any such explanation. ಟ್ರ್ಯಾಪ್ ಪಂಚನಾಮದಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ?
Like the paper book ನಾನು ಸಿಗ್ಲಿಲ್ಲ. I thought of before papers. Yeah.
ಇದೆಯಾ? Any explanation? ಟ್ರ್ಯಾಪ್ ಪಂಚನಾಮ?
ಇದ್ರಲ್ಲಿ ಲೆಕ್ಚರ್ ಮಾಜರ್ ಹಾಕಿಲ್ಲ ಇವರು ಪೇಪರ್ ಬುಕ್. This act in your tab.
Yes, there is there. The TLO then asked Srimati so-and-so for what purpose she had received the bribe amount from the complainant, for which she stated that she had received the amount for doing the work quickly during pressure of work. Yes. Negative for the following reasons. It is the contention of the prosecution that the accused was a public servant working as income tax inspector. This fact is admitted by the accused. It is the further contention of the prosecution that the complainant PW1 is an income tax assessor and submitted his income tax returns, claiming a refund of the excess tax amount deducted. Such excess was quantified as rupees 19,969 on the The check was issued by the department towards refund of the tax to the address that was mentioned in the system. Since the complainant had already changed his address, the check so sent was returned to the department. After coming to know about this fact, the accused PW1 approached PW6 income tax officer and requested to issue the check. At the instance of PW6, PW1 has submitted the application as per Exhibit P1, requesting for change of kata, change of address in the departmental system. PW6 in his evidence stated that on receipt of the application as per Exhibit P1, he referred PW1 to the accused who was working as income tax inspector. Accordingly, the complainant went and met PW6, met the accused and requested for change of address in the system. Next, PW1 in his evidence states that when he met the accused with a request to change of address in the system, the accused stated that she has changed the address in the system and demanded illegal gratification of rupees 1,000. The complainant was not willing to pay that amount. Filed the first information with the CBI as per Exhibit P3. Stating that there was a demand by the accused to pay the illegal gratification. She had even called him over phone at 7:30 p.m., 7:35 p.m. on 20th January 2011, demanding rupees 1,000. To change the address of PW1 for getting the refund of income tax. On receipt of the first information, Exhibit P3, the interestment measure as per Exhibit P4 was drawn on the same day, that is on 21. Six currency notes as referred to in Exhibit P4, that is one currency note of rupees 500, 5 currency notes of ₹100 were entrusted. To the informant, smeared with phenolphthalein powder. PW1 in his evidence states that after entrustment of the currency notes, he along with PW3, the shadow witness, went and met the accused in her office. He stated that when he met the accused in the office along with the shadow witness, and asked her whether she has done his work, the accused replied stating that she has changed the input in the system by changing the address and handed over the application with her left hand. Immediately, complainant gave signal to the investigating officer, who came to the spot along with punch witness PW10. Hand wash of accused in sodium carbonate solution was taken in separate bowls. It turned into pink color. Thereafter, the accused was asked regarding the tainted amount, which he produced from the table drawer. When the accused was asked as to why she has received the bribe amount, she stated that she has received the same for doing the work quickly. And therefore, the trap Panchanama was drawn. Next part. PW1, the material witness, being the informant, has deposed in detail about the official work that was pending in the department, demand and acceptance of illegal gratification by the accused, and recovery of the same by the investigating officer. This witness was cross-examined at length. Please believe his version. PW3 is the shadow witness, an independent public servant. He fully supported the case of the prosecution. Of course, during cross-examination, it is elicited that only one hand of the accused was washed. One hand wash of the accused had turned into pink color. With regard to the other particulars, no fatal adhesion is elicited. The investigating officer is examined as PW4 and the independent bench is examined as PW10, and all these witnesses were given evidence consistently in support of the case of the prosecution. Even though the witnesses were subjected to cross-examination at length, nothing has been elicited to disbelieve their version. Next part. It is pertinent to note that during cross-examination of the prosecution witnesses, the accused has taken inconsistent defense, saying that the check was directly handed over to PW1 immediately after change of address in the system. It was also suggested that the check was sent through post on the same day, that is on 20th January 2011. The third stand taken by the accused is produced by the prosecution to show that the check for rupees 21,360 was issued to PW1, and the same was cleared on 3rd February 2011, issued to PW1 on 22/1/2011, and cleared on 3rd February 2011. That is after the incident which had taken place on 21/1/2011. Next. It is the specific contention of the prosecution that the hand wash of the accused tested positive for the presence of phenolphthalein powder. Exhibit P Exhibit P25 is the chemical examiner's report, according to which the right hand wash tested positive for presence of phenolphthalein powder when she never demanded and accepted the legal gratification. Next part. The senior advocate for the appellant contended that Exhibit P1, the application was submitted by the complainant to PW1, PW6, the income tax officer, who was authorized to operate the system with the key and password. Accordingly, he opened the system with the help of the key and the password and asked a private computer operator by name Asha to change the address. Accordingly, it was the said Asha who effected change of address in the system, and the endorsement found on Exhibit P1 is that of the private computer operator and not that of the accused. But unfortunately, no such defense was taken by the accused before the trial court during cross-examination of the prosecution witness. Next. It is pertinent to note that Exhibit P asked him to meet her right now. The complainant asked how much is to be brought. The accused replied that she has already told him in the morning. PW1 asked to reduce the said amount, and the accused has categorically stated no. This conversation found in the digital voice recorder was transcribed, and the digital voice recorder was sent with the voice sample of the accused collected during investigation. Exhibit P33 is the report by this signed by as exhibit S1A. 1 ಅನ್ನೋದು ರೋಮನ್ 1 ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ ಎ ಕ್ಯಾಪಿಟಲ್ ಎರಡು ಕಡೆ. Even this report exhibit P33 is not disputed by the accused in any manner. Next part. From the materials on record which are referred to above, the prosecution is successful in proving the pendency of the work, demand for illegal gratification, acceptance of the same, and recovery of the tainted amount from the table drawer of the accused. The accused has denied all the incriminating materials in his statement under 313 of CRPC and produced the screenshot, copy of the screenshot obtained by him under Right to Information Act, according to which check bearing number 4021491809 was issued in the name of PW1 on 20th January 2011 for rupees 21,360, and the ECS was successful. The accused was working. And thirdly, such online transfer was done by the office at Mumbai. The accused, who was working as income tax inspector in the department, was competent to explain regarding the same, or at least should have sought for explanation by PW6, who was working as income tax officer in the department at the relevant point of time. Next part, the contention of the senior advocate for the appellant that no official work was pending with the accused, as it was PW6 who was authorized to operate the system, having key and the password to effect change of address, cannot be accepted in view of the categorical evidence led by the prosecution, which remained unchanged. If no such official work was pending with the accused, there was no reason for PW1 to approach the accused and have conversation with her. PW1 having met the accused and under such circumstances, I am of opinion that the prosecution is successfully proving the demand. Yes.
Dinesh Kumar Rao, okay.
Good. Order sheet. Password.
Number 12, L. Vidya.
Appear for the kindly 2 days accommodation. File misplace ಆಗಿದೆ, ಕಾಪಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ.
ಬಿಟ್ಬಿಡಿ, ಅವ್ರು ಮಾಡ್ತಾರೆ.
2 days
ಇದಾರೆ, ಕೂತ್ಕೊಳ್ಳಿ. Yes, proceed.
Ready, sir.
Yes, proceed. Kodi, trial court records. One not 9, appeal memo. Appeal number 243. 243. What about accused number 6? He has not preferred any appeal.
It appears.
Accused number 6 ಗೂ ನಾವು
ಯಾವುದು ಯಾವ ಅಪೀಲ್?
147 ಅಲ್ಲಿ
147 ಅಪೀಲ್ ಮೆಮೊ ಕೊಡಿ. Hmm, 2, 3 and 6.
ಹಾ.
What are the offense?
Flood 395, 397. The net section judge found guilty for 395,
Hmm,
acquitted in respect of 397.
395 conviction.
Conviction, 7 years imprisonment. Now 37 lakhs valuables. According to prosecution. Now 37 lakhs valuables. According to prosecution.
Gold worth?
For gold and cash both.
Huh.
30 valuable at cost of rupees 37 lakhs.
Hmm.
Main, sir, these thing, my lad, on 17/6/2010, according to prosecution, A1 is running a shop or in front of the house of PW1.
Hmm.
He has followed the movements of this PW1 and 2 inmates of the house.
Yes.
Keeping this as a situation, he has connived with the other accused and keeping watch over the movements of this PW1 and 2.
Hmm.
PW-A1 was inside the front side the house and 2 persons were outside the backside the house. And at that time, it is the prosecution case, my lad, 4 persons, that's more particularly accused 2 to 7 are backside, accused numbers 2, 3, 6 and 7 entered inside the house.
Accused number 2
2, 3, 6, 7, including my client, A7,
entered the house.
house
Hmm.
by plastering their mouth and tying the hands. PW 1 and 2, and they have robbed the PW 2, 3 and 4 by either side, backside movements. ಯಾರಾದ್ರೂ ಬರ್ತಾರೆ ಅಂತ ವಾಚ್ ಮಾಡ್ತಾ ಇದ್ರು. These 4 persons entered the inside the house, 2, 3, 6 and 7.
Yes.
Now the entire case is rested on the 3 circumstances, my lad.
Hmm.
Recovery,
Hmm.
test identification period.
Hmm. All the accused were identified in test
No,
identification
no.
period.
According to prosecution, they have identified,
Hmm.
but much earlier to their identification, they themselves stated they have seen in the police station. After police informed that accused were arrested, please come and show notice your jewels andaga, they themselves have stated that they have identified some of the accused in the police station, CCB.
What was recovered?
Recover valuables, all the
everything.
ornaments. Exhibit P,
Cash ಬಂದಿದೆ?
cash, some cash, specific agilla swami, but cash has been also seized. Then my lad, PW 56. Tahsildar is the PWC. Sixteen, my lad, PW 16, as per
Yaar, how many
Tahsildar,
witnesses? 1 minute.
Prison, Bangalore.
Hmm.
Then my lad, the major witnesses, PW 6, 7. All these, mainly they have not specifically so and so are present ಅಂತ ಎಲ್ಲಿನೂ ಐಡೆಂಟಿಫೈ ಮಾಡಲ್ಲ. I will point out that portion of the.
No, according to exhibit P25,
True, my lad.
PW 1 and 2 both have identified all the accused.
Some of them they have identified. My reasonable submission, my lad.
Sir, nim defense ಆಮೇಲೆ ಬರೋಣ.
That is
According to
true,
the
that is true.
prosecution.
They have identified. ನಾವು notice ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳಿ.
Yes.
So my reservation for that aspect is, my lad, much earlier to this TI period, it has been suggested and they have gone to the police station. In the police station, they have noticed.
ಆಯ್ತು ಅದ್ ನೋಡ.
ಇದು one circumstance. Second circumstance, my lad, even one paper, scrap of paper is not produced by the PW 16, requesting this PW 1 to 4 to appear before the, or go over to the police, central prison in order to identify the culprits in the test identification period.
Recovery at whose instance?
Different persons, PW, ನಮ್ಮವ್ರ ಹತ್ರನೂ
Madam? Huh?
Sender. The memo is placed on record. Proceed paid the PF for issuance, submits the paid PF for issuance of notice to respond number 2. Office to verify. If PF is paid, issue notice to respond number 2. Yes. ಬರ್ಬೇಕದು ರಿಟರ್ನ್ ಬರ್ಬೇಕಲ್ಲ ಬರಲಿ ನೆಕ್ಸ್ಟ್
Review of the appellant, my lords.
Appeal is dismissed. Yes.
Number 1, PM Shilwan. PM Shilwan.
Connect ಆಗಿಲ್ವಾ
Appear for petition number.
ಎಲ್ಲಿ ಆಗ್ತಾನೆ?
No, sir. Petitioners are respondent 1, 10 and others. The Lordship must quash the annexure D.
Yes.
No, sir, I kindly see the order of the RSA, which I called out in my petition itself. Lordship can turn to page number 26, Based on this RSA, Lordship dispose of the writ petition. Lordship can turn to page 26 and I called out the order portion.
Yes.
The second paragraph of the order, Lordship can see. Notwithstanding the dismissal of the appeals, the parties are at liberty to agitate their grievances before the competent authority, that is Assistant Director of Land Records, Belgaum, to whom the matter has been remanded by the Joint Director of Land Records. Office is hereby directed to send a copy of the order of Assistant Director of Land Records, Belgaum, to expedite the matter and take decisions as early as possible, so that the dispute between the parties could be resolved. This is the order, my lords. Now, my lords, virtue of this order, my lords, virtually we
Now,
cannot.
is there any reference? Where is the
Pardon?
reference to? Where is the reference to judgment of passed in the RSA? Na?
Your lordship can see, my lords, at page number 43 of the petition,
RSA.
review petition.
Yes.
It is stated that the private respondents have challenged the order of the second challenge order in the second appeal by preferring RS number so and so and so and so before the court. Admittedly, these appeals came Bangalore, and appeal number so and so and so and so Annex D is quashed, and the Annex D is the remand order, my lords. If that is sustained, my lords,
Now, what is your grievance, sir?
grievance, my lords, there is a discrepancy in the measurement of the lands, which is PODI was done. Your lordship can turn to the writ petition number, my lords, page number 29.
No,
Lordship
according
can
to
see-
you, what is the remedy?
remedy before JDLR, PODI is to be, there is a direction by the JDLR. The PODI is to be, my lords, conducted according to their possession and also title. Because there is a
Yes.
mistake in the entry made by the authorities. Your lordship can turn to page 29.
No, that liberty is reserved in RSA.
Virtue of your lordship's order, my lords, the liberty is gone now.
How?
Your lordship passed the Annex D, which is a remand order, which is sustained, my lords, by the in the RSA.
No.
RSA.
Just now you read the para number 6.
Yes,
What
ma'am.
does it mean?
Plus, this the lordship has said, my lords, since the RSA order is passed, Annex D, my lords, with reference to Annex D. In RSA, my lords, court has said, go before the Additional Director of Land Records, since the matter is remanded by JDLR. JDLR order, lordship passed it, my lords, now.
No,
Remand order, lordship passed it.
specific finding is recorded. I am of the opinion that the judgment and decree passed by the civil court and liberty reserved by this court in the second appeals would prevail.
Yes, ma'am. But an
The
entire
improved
Annex D is passed, that's all, my lords.
Hmm.
Page number
Ambiguity.
31 of the petition, page number 31 of the petition, that is JDLR order, which is remanded, which is confirmed in RSA. My anxiety is not that the authority will not consider because the writ petition is allowed and entire Annex D is passed. Page 31, my lords. This is a remand order. In RSA it is said, my lords, as per this order, go before the ADLR. That's all I want, my lords. Your lordship
This
can
order
say
was dictated in the open court.
my lords, I was not there because it's in
What is to be done?
no warning list it has appeared, but by mistake, my lords, I not appeared before the court. Therefore, I filed a petition. My lords, I apologize, my lords, for my absence.
No, I don't.
Only your lordship can clarify that the JDLR, as per JDLR order, as per RSA, direction of RSA, parties are at liberty to agitate the same before ADLR.
Sir, that is what is stated in para number 6. Why
But
it is to be once again clarified?
No, sir, operative portion,
Read
lordship.
read it once again.
Plus operative portion in lordship.
I am of the opinion that the judgment and decree passed by the civil court and the liberty reserved by this court in the second appeals would prevail over.
Yes, ma'am, but yes, ma'am, but the
What does it
lordship
mean?
allowed and no
Then
allowed
what
and
is to be clarified now?
absence on that day.
Issue notice to respondent.
Response 1 to 8, my lords, other response may be dispensed because they are co-respondents. 1 to 8, my lords, who are the petitioners?
Notice of RP to respondent number 1 to 8.
Yes, ma'am.
The petitioner seeks dispensation, other than first dispensation. Notice to respondent number 9 to
9 to, my lords, 9 to 69. 9 to 69.
Submission is placed on record. Notice is dispensed with. Issue notice to respondent number 1 to 8.
My request for a stay, my lord.
No, first notice ಹೋಗ್ಬೇಕಲ್ಲ sir.
Please,
Notice
please,
serve ಆಗಿ ಬಂದ list immediate after service.
please. That only clarification I need, that's all.
ಆಯ್ತು ಬರ್ಲಿ.
Please.
Admission, yes.
Admission, number 70, Uday Kumar and
It is not by me.
Yes.
Now, Churange.
Appellant is accused number 3.
My lord, yes, 3, my lord.
In all, how many accused?
There are 10 accused, my lord.
When you are arrested?
8824, my lord.
8/8/24. What about other accused?
Accused number 4 to 10 already entered on bail, my lord.
1 to 3 are in JC.
JC.
Where is the charge sheet?
My lord, charge sheet in page 55, my lord, in page
Yes.
55, my lord. 24/7/24 ಸಾಯಂಕಾಲ ಸುಮಾರು 4 ಗಂಟೆಗೆ A1 A2 ಆರೋಪಿಗಳು ವಯಂಬಾರ್ ಹತ್ರ ರಸ್ತೆಯ ಪಕ್ಕದಲ್ಲಿದ್ದ ಒಂದು ಮರದ ಕೆಳಗೆ ಸಾಕ್ಷಿ 23ರವರೆಗೆ ಸೇರಿದ KA 59M2830 ನಂಬರಿನ ಕೆಂಪು ಬಣ್ಣದ ಸ್ವಿಫ್ಟ್ ಕಾರ್ನಲ್ಲಿ ಕುಳಿತು ರವಿಯನ್ನು ಕೊಲೆ ಮಾಡಲು ಸಂಚು ರೂಪಿಸಿಕೊಂಡು ಅಲ್ಲಿಂದ 3 ಜನರು ಆನೇಕಲ್ ವೆಂಕಟೇಶ್ವರ ಟಾಕೀಸ್ ಹತ್ತಿರ ಬರುತ್ತಿದ್ದಾಗ ರಾತ್ರಿ 7:30 ಗಂಟೆಗೆ A10 ಆರೋಪಿಯು ಕಾರಿನಲ್ಲಿ ಕೂರಿಸಿಕೊಂಡು ಆತನಿಗೆ ಕಾರು ಚಾಲನೆ ಮಾಡುವಂತೆ ತಿಳಿಸಿ ಆನೇಕಲ್ ಉಪವಿಭಾಗದ ಆನೇಕಲ್ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದು 22ನೇ ವಾರ್ಡ್ ಬಹದ್ದೂರ್ಪುರದಲ್ಲಿ ವಾಸವಾಗಿದ್ದ ಮೃತ ರವಿಯ ಮನೆ ಒಳಗೆ ಮೊದಲು A1 ಮತ್ತು A2 ಆರೋಪಿಗಳು ಹೋಗಿ ರವಿಯನ್ನು ಹಿಡಿದುಕೊಂಡು A1 ಆರೋಪಿ ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ಲಾಂಗನಿಂದ ಮೃತ ರವಿಗೆ ಹೊಡೆಯಲು ಹೋದಾಗ ರವಿ ಇಬ್ಬರಿ ಕೈಯಿಂದ ತಪ್ಪಿಸಿಕೊಳ್ಳಲು ಪ್ರಯತ್ನ ಪಟ್ಟಿದ್ದ ಸಮಯಕ್ಕೆ A3 ಆರೋಪಿಯು ಮನೆಯೊಳಗೆ ಹೋಗಿ ರವಿಯನ್ನು ಭದ್ರವಾಗಿ ಹಿಡಿದುಕೊಂಡಾಗ A3 ಆರೋಪಿ ಬಳಿ ಇದ್ದ ಚಾಕುವನ್ನು A2 ಆರೋಪಿಯು ತೆಗೆದುಕೊಂಡು ರವಿಗೆ ಒಂದೆರಡು ಬಾರಿ ಚುಚ್ಚಲು ಪ್ರಯತ್ನಿಸಿದಾಗ 3 ಜನ ಆರೋಪಿಗಳು ರವಿಯನ್ನು ಭದ್ರವಾಗಿ ಎಳೆದುಕೊಂಡು ಮನೆಯ ಮುಂದಿನ ರಸ್ತೆಗೆ ಎಳೆದುಕೊಂಡು ಬಂದು A2 ಆರೋಪಿಯು ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ಚಾಕುವಿನಿಂದ ರವಿಗೆ ಮನಬಂದಂತೆ ಚುಚ್ಚಿ ತಿವಿದು ಕೊಯ್ದು ಸುಮಾರು 16ಕ್ಕೂ ಹೆಚ್ಚು ಕಡೆಗಳಿಗೆ ತೀವ್ರ ಸ್ವರೂಪದ ರಕ್ತಗಾಯಪಡಿಸಿದ್ದರಿಂದ ರವಿ ರಕ್ತದ ಮಡುವಿನಲ್ಲಿ in complaint page 29. In page 29, my lord. Complaint.
29 other initial stage ನಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ, initial stage.
Yes.
In that complaint, there is no such averment against me, my lord.
Correct. Who is
During
the
the inquest also, my lord. During inquest also, the brother and sister of
How many
the
witnesses are cited?
cited, my lord.
Whether complainant is an eyewitness?
Complainant is not an eyewitness, my lord. Only one witness, CW2, is an eyewitness to the alleged incident. And his statement was recorded after the 4 days.
Yes. Well, I am not giving a judgment of acquittal, sir.
Please.
ಅಷ್ಟು ದಿನ ಆಯ್ತು, ಅದು ಡಿಲೇ ಆಯ್ತು, ಅಲ್ಲಿ ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ, ಇಲ್ಲ.
Please,
We are preliminary stage.
ಹೌದು ಸ್ವಾಮಿ, ಈಗ accused number 4 to 10 were already entered on bail.
Yes, there is no such overt act against them.
Yes, for me also, against me, entire investigation release, I am held the deceased, my lord. I have not assaulted to the.
You are armed with a knife, you held the deceased. Accused number 2 snatched your
Respondent number 2.
EM report ಇದೆಯೇನ್ರಿ?
ಇದೆ sir.
How many external injuries?
External injuries, my lord. Totally 16, my lord, totally, which asserted by him.
Hmm. Not entitled.
Then my permit to withdraw.
Yes. Counsel for the appellant, after addressing the argument at length, seeks permission to withdraw the appeal. Submission is placed on record. Yes. Charge sheet is filed.
Yes, my lord. Charge sheet is filed.
Yeah.
It's also numbered. Special case 5010 of 2025.
Now, what is the stage?
It has got to be heard on framing of charges and other aspects, my
Please come to page number 61. What is the allegation?
charge sheets only.
Yes. Column number 7.
Yes, my lord.
What is the allegation?
Allegation is, my lord, could I make a submission, my lord? The allegation over here has been aggravated because as for the FIR, what has been stated by the complainant, the wife of the deceased, is that she was present when her husband asked her to accompany him to pluck jackfruits. And they have gone to the field of the accused were here in my lord, and she was standing at a distance, and the husband went to pluck the jackfruit, and he has plucked 2 jackfruits and he has put it over there. And then before he could take it, the accused was coming that side with a dog in his hand and along with a gun. And seeing the deceased over there, he has told him,
Be considered at a bail petition.
my lord, there is one submission.
If
My
I
lord,
were to accept your contention, what remains for the trial court?
my lord, there is one submission. There is no intention to kill him. There is no intention. Only once the accused has shot him, only once, the pellet gun. And that too,
PM report. Where is the PM?
PM report, my lord, is at page number 66 wounds, my lord. PM number is at page 97. Pellet gun, my lord, it breaks and number of pellets enter the body. There are 66 injuries on a 19-year-old boy.
the number of injuries 19, I am not disputing, sir.
How many injuries? 66.
66 multiple and
How many injuries? 66.
66 multiple entry wounds, 66 in number. My lord, if my lord is, there are also photos of the injuries, my lord.
If there was only one shot, how can 66
Pellets, my
multiple
lord.
Pellets, my lord, small pellets.
enter?
It will just
Pellets,
break.
my
and-
lord.
it-
It's pellet. It's been fired only once, and those are the exit wounds, my lord. My lord, the firing has taken place from a distance of
Exit entry unda, exit unda, ಏನದು? Exit.
entry wound. Entry wound, I'm sorry.
Entry wounds.
Entry wound.
ಎಲ್ಲಿದೆ
It's
ಅದು?
pellets. So
Where
what
it is
happens, it
mentioned?
spreads.
My lord, it's written at page 97 in the mid, at the bottom of the page. One multiple entry wound, 66 in number.
Thereafter, he is taken him to the hospital, but when they reached the hospital, the doctor examined and said that he is dead.
Eyewitness is CW1, my lord. She's given 164 statement as well. 183 statement, my
That is the
lord.
wife of the deceased.
Wife, my lord. She has given the statement before the magistrate, my lord. It's at page 202. Page 202, my lord. Helike is on page 203, my lord. It is what is there in the column number 17, my lord.
ಇದರಲ್ಲಿ ಇಟ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್ಲಿ ಸ್ಟೇಟೆಡ್. ಆ ಸಮಯದಲ್ಲಿ ಚಿನ್ನಪ್ಪ ಅವರ ಕೈಯಲ್ಲಿ ಕೋವಿಯನ್ನು ಹಿಡಿದುಕೊಂಡು ಬಂದು ನನ್ನ ಗಂಡನ ನೋಡಿ ಅವರನ್ನು ಕುರಿತು ಎಪ್ಪಣ್ಣು ಎರವ ಸುಳೆ ಮಗನೇ ಬೋಳಿ ಮಗನೇ ನನ್ನ ತೋಟದಲ್ಲಿ ಹಳಸಿನ ಕಾಯಿ ಸಿಕ್ಕಿದೆ ನಿನಗೆ ಎಂದು ಬೈತಾ ಕೋವಿಯಿಂದ ಗುಂಡನ್ನು ಹಾರಿಸಿದ್ರು. ಸೊ there is no threat that I'm going to kill him. It only says that is it my field only which you found to pluck the fruits, and he has shot him. So that shows that he had no intention to kill him, my lord. He only
What was the intention then?
in Bangalore, and he is the only other person. There is nobody to even take care of the wife who is suffering from the cancer. More than that, he is also a heart patient, my lord. He's already had 2 stents operation 2 times stents have been this thing, and he has also got to take care of him, not only himself,
course.
more than that his wife.
Of course, but he has taken away the life of a person.
True, my lord, but it's not intentionally. The intention was not that. It has happened at the spur of the moment. It's not that he wanted to kill him or anything.
Intention is to be gathered from the circumstances.
Yes, at this stage, the circumstance which is shown over here, it doesn't say
He
that
has seen
anything.
the deceased plucking the coconut, jackfruit,
ಇದರಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು
abused him, shot at him. What may be the
ಇದರಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು
intention?
ನಾನು ಸಾಯಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿ ಮಾಡ್ಲಿಲ್ಲ. ಈ ಸಿನಿಮಾ ಶಾಟ್ ಇನ್ ದ spur of the moment. What transpired in his mind at that time, that should be looked in time of evidence. But at this stage, suffice to say is my
Yes, what is
respectful submission, my lord.
This is in fact, the charge sheet, my lord, column 17, this is not the first time. The appellant, my lord, has the history of behaving with Yaravas, which is the community that the deceased belongs to. It's a Adivasi community, my lord, extremely dominated community that lives in Kodugu. They all live on the line houses over there, like the victim over here, my lord. They work in the coffee estate. So this, my lord, is a sheer caste atrocity, and only because he was plucking a jackfruit, my lord, he was shot dead. That, my lord, is undisputed. In fact, the pleadings itself may please be seen. Para numbers.
No, 1 minute. Charge sheet, column number 7, page.
Please, my lord. Page 6 may please be seen. Para 8. Para 8 and 9, my lord. There is no denial. Running page 6, please. In page 6.
Page 6 of
The
charge sheet.
illa our appeal. Para number 8 of their appeal. Pleadings. The alleged allegation on the appellant having committed an offence under section 1031 alleging murders without any merits. Please note, it is submitted that from the investigation it is clear that the accused has fired on the deceased only once, the same having been done from a single barrel gun. It is submitted that the said weapon allegedly used is a licensed gun registered in the name of the accused, and the license since then has been seized during the course of the investigation. Idu shoot ಮಾಡಿದ್ದು deny ಮಾಡ್ತಿಲ್ಲ. Gun ಅವ್ರದಂತ there is no denial at all.
Yes.
The only thing that is being made out now is to say that it's probably because of some monkeys that were there that a human being has lost his life. My lord, may please see the school certificate at page 185. The age of the deceased is 18 years old, my lord. Page 185.
Yes.
His date of birth, my lord, is 27/3/2006. I've already pointed out, my lord, 164 statement CW1, who is the eyewitness. As
No,
please,
there
my
are
lord,
there are materials to.
and there are many,
constitute offence.
yeah, and witnesses are there. CW4, CW5, they also say that they saw him walking back with the gun. So the other thing, my lord, is that he is a very influential person, my lord, by virtue of also which community he belongs to. I'm also just filing my objections just for the sake of completing the pleadings in this, my lord. The UDR report, my lord, is at page 83.
What is this?
My lord, I'm just formal objections, my lord.
Right.
Just for record,
Yes.
nothing. The UDR, my lord, is at page 83, which again speaks about the manner of the incident, my lord. The photos of the victim, my lord, are from page 93 onwards of the kind of injuries that he suffered.
So now at present, the undisputed facts that are placed before the court is that he was plucking jackfruit from your.
True, my lord.
And shot.
Yes.
He shot at the,
Shot and killed. Yes, my
as a
lord.
result of which he fell down and on the way to hospital, he died.
Yes,
It is lost. That is the
undisputed.
fact.
Yes, my lord. That
Why,
at this
why
stage,
he is to be detained in custody?
my lord, insofar as the,
Only your apprehension is that he is from dominating community, he may influence.
my lord, that is one of, of course, my lord, grant of bail, my lord, one will also have to see the seriousness of the offense, my lord, all of that. In this case, my lord, there is no dispute. There is not even a effort being made to say that I did not do this.
That it is not a case of prosecution, that it is a premeditated murder.
Just a minute. My lord, may please see the 164.
164 ಇರ್ಲಿ ಸರ್, ಚಾರ್ಜ್ ಶೀಟ್ ಏನು ಹೇಳ್ತೀರಾ? 164 ನಲ್ಲೂ ಅದನ್ನೇ, ನನ್ನ ತೋಟದಲ್ಲಿ ಹಲಸಿನಕಾಯಿ ಸಿಕ್ಕಿದ್ದ ನಿನಗೆ ಎಂದು ಬೈಯುತ್ತಿದ್ದ ಕೋವಿಯಿಂದ ಗುಂಡು ಹಾರಿಸಿದರು.
ಚಿನ್ನಪ್ಪ ಅವರು ಕೈಯಲ್ಲಿ ಕೋವಿನ ಎದುರುಕೊಂಡು ಬಂದು ನನ್ನ ಗಂಡನನ್ನು ನೋಡಿ ಅವರನ್ನು ಕುರಿತು, ಏ ಪೊನ್ನ ಎರವ ಸೂಳಿ ಮಗನೆ, ಬೋಲಿ ಮಗನೆ, ನನ್ನ ತೋಟದಲ್ಲಿ. The reason, my lord, is because of this.
Because he was plucking the coconut from his garden.
Please, my lord, my humble submission is this, my lord. A case like this, my lord, where this kind of a cold-blooded murder is carried
Yes,
out,
of course.
it has a very chilling effect, my lord.
Wherever 302 of IPC or the present BNS is invoked, it will be.
Please, and more so, my lord, now in the event, my lord, where this is a known fact that this person has been killed, there is no denying of that. Bail is granted, my lord. In so far as at least the witnesses are concerned, my lord, it is not just about, it's the kind of terror that is going to be created, and of course the message that is going to be sent, my lord.
In such a case, definitely you or the prosecutor definitely can seek cancellation.
My humble submission is this, my lord. Let the trial commence, my lord. Let the eyewitnesses, let their
Still
witness.
at the stage of HBC, sir.
Let that be accelerated, my lord. But if bail is granted at this point, my lord, the kind of message that will be sent, my lord, is,
If you are
my lord, that's a different matter. But if the bail is granted before CW1 gives evidence, my lord, it is going to have a chilling effect on the trial, my lord. That is the nature of things in the place over there, my lord. For a free and fair trial, so that the victim at least gets some justice, my lord. My humble prayer would be this, that at this stage, if bail is granted,
see, it is a very settled position that the detention of the accused in custody during trial cannot be a pre-trial punishment.
please, my lord, I'm of course, my lord, I've always argued on that side, so I'm always of that opinion.
Cannot be considered as a punishment.
Not at all. In fact, my lord, my only submission is this.
There is some specific reason to detain the accused in custody.
My lord, my submission is this, my lord. If my
Your
lord,
only apprehension is that the accused may threaten or influence CW1.
my lord, there are two reasons. One is, my lord, insofar as prima facie involvement is considered,
Yes.
that, my lord, has to be looked at. Gravity of the offense, my lord, the probability of interfering with the trial, my lord, more or less these are the grounds that would have to be looked at. Prima facie, my lord, there is no doubt, my lord. Prima facie, there is an admission that the appellant is the one who killed the deceased. Insofar as the gravity, my lord, that there is no difficulty. Insofar as interfering with the fairness of the trial, my lord, that is also extremely probable, my lord, giving the social location of CW1, which is why, my lord, my humble submission is this, that at least let the evidence of the eyewitness, my lord, CW1, let that be completed. After that, my lord, bail is granted, at least a fair trial will be ensured, my lord. My humble submission is that this will.
Yes, what do you say?
My lord,
Let CW be examined before the trial court. Thereafter, you renew your prayer.
one submission, my lord. Let there be conditions that I got report to the police station once in a week or something. And then I undertake that I'll not, still I'm doing it as your lordship suggested, let them move for cancellation. Because I'm not going to violate.
See, once the bail is granted, cancellation is very Herculean task.
My lord, and as far as I'm concerned, my wife is suffering from the fourth stage cancer. She
to
may
do?
collapse any moment.
See,
There is nobody to take care of her, my lord.
Deceased was 18 years. CW1 is 19 years. She is a lady belonging to socially backward class. What will be her plight, sir? She has lost her husband. What she should do?
Recently married, my lord.
I'll leave it to the court, my lord.
So
I'll leave it to the
let her be examined. Later you can renew your this one.
Let that be an order.
On merits?
Not on merits, my lord.
Okay.
After this thing,
You are withdrawing this?
I'll withdraw, my lord.
The council after so and so seeking permission to withdraw the appeal with liberty to renew the prayer after examination of
CW1.
CW1.
Grateful, my lord.
Yes.
Please, my lord.
Milord, on behalf of Vinay Shresh, he's filed the retirement memo. His name,
Appellant. Counsel for the appellant filed a memo seeking permission to retire from the case, stating that the copy of the letter addressed to the High Court Legal Services Committee dated 18/6/2025 is enclosed with the memo. Taking into consideration the memo and the document annexed to the same, counsel for the appellant is permitted to retire. Appellant called out absent. So and so is appointed as amicus curiae. Amicus curiae. So and so is appointed as amicus curiae to represent the appellant and to assist the court in disposal of the appeal on merits. Yes.
name may be deleted.
Office is directed to delete the name of so and show the name of amicus curiae.
That
Yes.
Serial number 7.
ಅದು ಒಂದ್ ನಿಮಿಷ ಮೆರಿಟ್ ಅದು ಅರ್ಧ ಆಗಿದಿಲ್ಲ. ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ. ಅದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀವಿ ಪ್ಲೀಸ್ ಒಂದ್ ನಿಮಿಷ. ಎಸ್.
May I request for tomorrow, my lords?
ಎಷ್ಟು ಹೌ ಮಚ್ ಟೈಮ್ ಯು ಮೇ ರಿಕ್ವೈರ್?
I will complete in another 15 to 20 minutes. My brother is also.
ಅವ್ರದ್ದೇನಿಲ್ಲ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಒಂದೇ.
ಒಟ್ಟಿಗೆ ಅವ್ರಿಗೆ.
ಹಾ.
But what?
ಬೇರೆ ಬೇರೆ ಏನಿದೆ?
4 appeals ಇದೆ.
ಹಾ
4 appeals ಇದೆ totally.
ಇರ್ಲಿ.
ಎಲ್ಲ ಅವ್ರ.
ಫ್ಯಾಕ್ಟ್ಸ್ ಒಂದೇ ಕೇಸು.
ಅಲ್ಲ ಒಂದೇ ಕೇಸ್.
ಒಬ್ಬರು ಒಂದೊಂದು ಹಾಕಿದ್ದೀರಿ ಅಷ್ಟೇ.
That is true. 2 appeals is not.
ಫ್ಯಾಕ್ಟ್ಸ್ ಒಂದೇ ಕೇಸು.
ಅಲ್ಲ ಒಂದೇ ಕೇಸ್.
ಒಬ್ಬರು ಒಂದೊಂದು ಹಾಕಿದ್ದೀರಿ ಅಷ್ಟೇ.
That is true. 2 appeals is not.
ಫ್ಯಾಕ್ಟ್ಸ್ ಒಂದ್ಸಲ ಹೇಳಿದ್ಮೇಲೆ ಮತ್ತಿನ್ನೇನಿದೆ ಅದ್ರಲ್ಲಿ ಹೇಳೋದು? Is the appellant on bail. It is noticed that the appellant was in custody during trial. He already spent 4 years 10 months in custody. 4 years 10 months in custody, as per the office note. Under such circumstances, I do not find any reason to entertain the application. Appeal is already admitted. Trial court records are ಬಂದಿದಲ್ಲ? Trial court records. Trial court records are already received. Under such circumstances, IA 1 of 2023 is dismissed. Counsel for the appellant submits that he will address the arguments on merits on the next date of hearing, list for final hearing. Yes. Since the appellant is in custody. Please. He is in custody. Please. What is exhibit P25?
P20.
one chaku, one machu, one kaki,
Mobile phone.
Then,
plaster road,
plaster road.
gold, ಒಂದು ಕಪ್ಪು ಬಣ್ಣದ ನೋಕಿಯಾ ಮೊಬೈಲ್ ಫೋನ್ which belonged to A1, your lordships.
Recovered at the instance of accused number 1.
Your lordships, all accused persons.
A1 to
6.
Joint recovery.
joint recovery.
Mobile phones which belong to the accused persons, your lordships, one Rexing bag,
How many phones?
6 phones.
6. P5 is the house, in the house of Srinivas.
Who is Srinivas?
Accused number 4, your lordships. Stolen articles, accused number 1 to 6, your lordships, was given to the custody of accused number 4. All the
Stolen articles ಯಾವುದು ಏನು?
It's a long list, your lordships.
ಏನದು?
All golden.
Gold articles.
Gold articles.
ಅದು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಲ್ಲ, ಸುಮ್ಮನೆ ಗೋಲ್ಡನ್ ಆರ್ನಮೆಂಟ್ಸು ಕ್ಯಾಶು ಅಂಡ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಷ್ಟು ತಗೊಂಡು ಹೋಗಿದ್ದೀರಿ ಸರ್ ನೀವು? ಎಲ್ಲಿ
Sorry, sir. That is true.
Then
According to us.
gold ornaments ಮತ್ತೇನಿದೆ?
Gold ornaments, there is mobile phones.
Belonging to accused number 4.
No, your lordships, this is regarding the stolen articles.
ಏನು?
ಜರ್ಕಿನ್, ರುದ್ರಾಕ್ಷ,
ಏನು ಜ್ಯುವೆಲ್ರಿ ಅದು?
ಜ್ಯುವೆಲರಿ.
ಒಂದು ರುದ್ರಾಕ್ಷ, ಒಂದು ಟಿ ಶರ್ಟ್.
Then my lord, P7, A7, gold chain and hanging. Then my lord, most one, 11, 14 and 18.
Which witness speak about exhibit P4, 5, 6, 7?
Please, my lord.
6, 7, 8, 9.
Lord, starting from Govardhana PW6, speaks regarding P4, P5. P3 spot major, P4 CCB office nalli madiddu, P5 in the house of Srinivasa, A4.
PW6.
6
Who is the other witness?
and PW, page 96, para 4. PW7 also same.
Yes.
Then PW8 he identifies one accused, sir. A4 he identifies.
PW8.
Yeah, we right. ಇವರು PW, sorry my lord, PW10 ಆಮೇಲೆ finish. Syed, PW7 also, 8 also not identified. PW10 A5 ಅವ್ರನ್ನ ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾರೆ. ಶ್ರೀನಿವಾಸ ಐಡೆಂಟಿಫೈಡ್ MOS 11 to 13.
That was recovered under which measure?
Under exhibit P5 my lord, Kalidasa layout.
Yes.
Recovery so far as this aspect. 11 and 12 are hostel, Taran hostel.
ಹೌದಾ?
P4, PW6.
6 and 7.
And Govardhan.
PW6 is Mazda witness to exhibit P3, P4 and P5.
Who is the other master witness?
Syed Parvez Ali, PW10.
There is no other Mazda witness. That's the only witness for exhibit P.
What about PW10? He says PW10.
Then PW10 is Mazda witness for exhibit P5, which is the seizure from accused number 4. Stolen article.
PW6 is the master witness both to exhibit P4 and 5. 4 and 5.
P4 and 5.
3 BD spot master.
Exhibit P3 is spot master, exhibit P4 is weapons, exhibit P5 is seizure from accused number 4.
PW6 and 10 are the master witnesses.
So your PW10 is only master witness for exhibit P5.
P4 ಗೆ 6 and 7.
P4 is 6, your worship. No, your worship, for exhibit P4, there is only one master witness.
PW6. Then
PW7 is master witness for exhibit P6 and P7. PW7. PW8, your worship, is again master witness to exhibit P6 and 7.
okay. Who turned hostile? 6 has not identified.
No,
6, 7, 8 they have not identified.
ಪ್ಲೀಸ್. ಹಾಸ್ಟೆಲ್ ಎಲ್ಲ ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕಾಯ್ತು, ಮಾಡಿಲ್ಲ, ಹಾಗೆ ಬಿಟ್ಬಿಟ್ರು.
Only PW10 has identified accused number 4.
4.
ಎಲ್ಲಿದ್ದೀರಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಿದೆ ಇದರಲ್ಲಿ? ಡಿಪೋಸಿಷನ್ಸ್ ಎಲ್ಲಿದೆ ನೋಡಿ, ಇದೇನಕ್ಕೆ ಇದು ಬೇಡದ ಇದ್ದು, ಡಿಪೋಸಿಷನ್ಸ್ ಎಲ್ಲಿದೆ ನೋಡಿ, ಇದೇನಕ್ಕೆ ಇದು ಬೇಡದ ಇದ್ದು, ಇದನ್ನು ಕಳ್ತೀವಿ ನೋಡಿ. ಡಿಪೋಸಿಷನ್ಸ್ PWs ಫ್ಲಾಗ್ ಹಾಕಿ. ಅದೇನು ಮಿಸ್ಲೇನಿಯಸ್ ಫೈಲ್ ಅನ್ಸುತ್ತೆ ಇದು.